All right, good morning.
Morning, Judge.
All right, first of all, let me call the case of State of Florida versus Hernan Herrera. This is case number 177820 CF10A. Apparently, the state and the defense have agreed on an order or stipulated to a bond reduction and a lifting of the NEBI order. So I'm going to go ahead and grant that. Today's the 21st day of July. Okay. All righty. Woodrow Blount, Mr. Jellen's not here, I'll pass it.
Judge, the jail contacted me up
Yeah.
in North Broward. They have a young lady they'd like to call out of turn. I spoke with this young lady. I think that it would be a good idea to call her case. She's
All right.
on page
Just tell me the name. Pages
6,
mean
Daisy
nothing
Phillips.
to me. Okay.
Thank you, Your Honor.
All right. Good morning, Ms. Phillips.
Good morning.
I do find probable cause to believe you should be able to answer for an alleged battery on a police officer, also resisting or obstructing an officer with violence, violation of a county ordinance you didn't go to court on, so there's capias on you for that, and also sleeping in public on a bus bench. All right. From what I can tell, this young lady is homeless. Is that correct?
No,
I believe
I'm not
so,
homeless.
Judge.
You're not homeless?
No, I was missing from medical. I had just signed in. So after
What?
medical,
Slow down. And I don't know if your attorney's going to want you to say anything.
I didn't sign for it, Sonny. I for the pre-trial.
Okay, here's the thing, though. You missed court, so I can't put you in pretrial.
What was my charge?
All right. In any event, I'm going to set bond in the first case, given the nature and the amount of $1,000. Bond in the second case in the amount of $1,000. And for the county ordinance, I'm going to go ahead and ROR you. And as far as the sleeping in public, there is a $100 bond on you for that. So your total bonds that you're going to have to post to get out are $2,100. Do you have somebody you could call to see about posting bond for you?
No, but I was supposed to be a Broward Medical Center. I'm not even supposed to be held at a prison.
How old are you?
I'm 56, and I had just came from Apple Medical, and I was going for a transport. They had tried to
Okay,
transfer
ma'am,
me to Broward
ma'am,
Medical.
in view of,
And I wasn't even sure. I had just signed in.
ma'am,
to Broward
ma'am,
Medical.
in
That's
view
at
of what,
10:26.
ma'am, in view
And
of
it
what
started
happened,
at 10:30.
okay, in view of what happened, you have to post bond in the amount of $2,100. Thank you.
So why I keep getting missing in medical, and y'all take me to jail for nothing?
Okay. Waikiki Jean? I'm just calling him in the order I pulled him here. Okay.
Your private counsel there.
Yes. All right. There is a warrant for your arrest for alleged trafficking in heroin more than 4 grams, less than 14 grams. Bond in this case is set in the amount of $250,000. And also using a two-way. Can somebody push that button so I don't have to listen to that? Use of a two-way communication device to facilitate a felony. Bond in that case is set in the amount of $5,000. Total bonds in your case are $255,000.
And Your Honor?
Yes.
They would just request that, I know Judge Usan also put a special bond condition.
Right, and in the event that you do post bond, you are to, there's going to be a NEBI hearing to make sure any of the money used, any property used to collateralize the bond shall not be further encumbered or liquidated during pendency of the bond. The bond should be fully collateralized. The net value of the collateral must be in an amount equal to or greater than the bond amount. The surety shall provide to the state an updated title search within 10 days of the defendant's release reflecting recorded mortgages on the properties utilized for the bond collateral. Defendant will be monitored, I guess that's level 1, by pretrial services, and the defendant will not possess any firearms. Okay.
May I be heard briefly in response to bond?
Sure.
First, for the record, Ashley Kay, and so Mr. Jean knows I'm standing in for his attorney, Regina Tasambanakis, this morning. Your Honor, I'd want the court to know that Mr. Jean does have another case. It's a possession of cocaine. It's a pending charge. He hasn't been convicted of it, and he has been out on bond in that case.
Oh, well, let me go ahead and revoke bond in that case as well.
Well, his bondsman is here, Angelita Carter, and that case is before Judge Dennis Bailey, so I don't know if anything that happens today may
Well,
need
I'm going to revoke bond based on this arrest.
We're of course asking Your Honor to set bond in both cases and
Okay.
perhaps lower the bond in the case before Your Honor. And just briefly, Your Honor, Miss Angelita Carter is present. She is willing to keep Mr. Jean on his current bond. He has been out on bond in that case. He hasn't had any issues, of course, except for the present case before Your Honor. We do not object to the special conditions, and in fact, Ms. Carter did recommend a pretrial services. However, I would ask if Your Honor would consider lowering the bond. The nature of the offense, it's based on the word of one confidential informant. There's alleged to be one transaction between Mr. Jean and the confidential informant. The other case is a possession case. I wanted to, in all candor with the court, wanted to let Your Honor know that. We do have a bondswoman here. And I would ask if Your Honor would consider lowering the bond. It's set at $250,000 right now on count 1. That's not something that Mr. Jean is able to post in any way, and I would ask if Your Honor would consider lowering it to $50,000 at this time, and also to set a reasonable bond on the possession of cocaine case.
All right, as far as his being out on the previous possession of cocaine charge, I'm revoking bond, ordering a no bond hold on him. On your motion to reduce the amount of the bond, that's denied. You can take that up with the division judge.
Yes, Your Honor.
Excuse me, Your Honor.
Just for the record, the case
And-
number on the pending case
Please.
is 16-7487 CF10A, and Eric Linder on behalf of the state.
The warrant says pretrial services. If it does not indicate GPS, that is standard for us. Are you changing it to level 1 GPS?
Yes.
Oh.
I have to sign them all? Oh, I'd have thought I could just sign one, no. Oh, I didn't have my stamp. Okay, that's why I didn't sign them.
Yeah, I told you, whenever you see, whenever it's on number 1, it's
GPS level 1 is
All right.
BSOP.
The bond
James
remains the
Barr.
same.
Thank you, Your Honor.
I don't even care what she says to the bond, because he can't get out before he sees the judge anyway.
Okay.
Thank you, Your Honor. Good morning. Raphael Hagan's appearing on his behalf.
James Barr?
Counsel, can you state that again? I'm not sure.
Yeah,
I got
Ralph
it.
A. Hagan's on behalf of Mr. Barr.
Okay.
Judge,
Wait.
They're going to get him right now. He's in the back, Judge.
Okay, I'll pass it for another moment, because we're calling it out of turn.
Keys on?
Kenesha Harris.
North Broward.
Okay.
Morning, Judge.
All right,
I
good
did
morning.
speak
Wait,
with Ms.
she's not there. There she is.
I did speak with Ms. Harris, Judge, and she indicated to me that she would like to resolve this matter.
All right. That's fine. All right.
Judge, I did notify her that there is a $32.10 restitution that she must pay to Reginald Cherry within 60 days. I have the address where she has to send it. I also provided my phone number to her through the deputy, and she needs to know that if she doesn't pay it, the city of Fort Lauderdale will issue an order to the court for a motion to compel, and if she doesn't show up for that, there'll be a warrant for her arrest.
Okay. And you want to put your appearance on the record?
Yes, Judge. Jara McLawrence.
All right, Ms. Harris, if you want to resolve this case today by pleading no contest, I'll take note of your time in jail in lieu of court costs. However, I will order you to pay restitution regarding a cab fare in the amount of $32.10 according to the conditions that's in the order here that were stated by Mr. McLawrence, and withhold adjudication as well. And if you don't wish to accept that, you're going to have to post bond in the amount of $2,000 to go through the court system, or basically you're going to have to stay in jail until this is resolved in division. But if you did want to do that, that would be going to court on next Wednesday. So do you want to resolve the case today?
Yes.
Okay, so ordered. Brandon Park.
Good morning, Judge.
All right, good morning.
How are you?
Okay, 1 second. Um, 1 second. Is this the one?
16.
All right, I do find probable cause to believe that Mr. Park should be held to answer for the charge of trafficking in heroin.
Am I supposed to be able to see him on the screen, Judge? 'Cause
I'm sorry, where is he?
I just see a deputy in front of me. I'd like to.
Oh, I'm sorry, thank you. There we are.
Okay, good morning, sir. Your cousin Anthony Archie hired me
All
to
right,
represent
sir, you are here. Okay, Brandon, let me start again. I find probable cause to believe you should be held to answer for the charge of trafficking in heroin, 4 grams or less to 14 grams. Bond in that case is set in the amount of $250,000. Also, they're using a two-way communication device to facilitate a felony. Bond in that case is set in the amount of $5,000. In the event you do post bond, you're also subject to the following special bond conditions. Your bond would have to be fully collateralized. The net asset value of the collateral must be in an amount equal to or greater than the bond amount. Any property used to collateralize the bond shall not be further encumbered or liquidated during the pendency of the bond. The surety shall provide to the state an updated title search within 10 days of the defendant's release, reflecting recorded mortgages on the property utilized for the bond collateral. The defendant will be monitored by pretrial services, and the defendant will not possess any firearms. And that would be monitored with the GPS level 1.
Judge, I'm
Yes.
asking you to substantially reduce the bond. Client's 25 years old. I researched him while I was waiting this morning. He had a 15 felony case which was dropped. My understanding, he has no prior He has no prior felony.
Counsel, you didn't put your appearance on the record.
Richard Bellis, for the record, Your Honor. He has no prior criminal history, my understanding. He's a lifelong resident of Florida. He resides in Margate with his mother. He's gainfully employed. His fiancée is present in court. Stand up for the court. She's 3 months pregnant, Your Honor. He's got numerous family members who reside here locally. It's a 3-year mandatory minimum. I believe the standard bond for a trafficking in heroin, in my experience, is usually $25,000, $35,000, or $75,000. A $250,000 bond for a single transaction with a confidential informant who half of the docket, there's 11 individuals who I believe were arrested, got caught up in the web of that confidential informant. I'm asking if you would substantially reduce his bond. That bond is clearly excessive. He has no history of failing to appear, and he has no criminal history.
All right, that request is denied. However, since he is employed in the event he does post bond, I'm going to make it a level 2, monitored by pretrial with a GPS. He would have to provide a schedule of all necessary absences from his home.
Judge, and I'm going to object for the record. I mean,
That's fine, counsel. I've ruled. Jacqueline Defoe.
Good morning, Your Honor. Ms. Defoe, that's Paul Ryan.
She's in Paul Ryan.
Thank you. All right. Ms. Defoe, I find probable cause to believe you should be held to answer for an out-of-state felony. This apparently is an additional charge to some other matters that you have pending. There is a no bond hold on you for that charge. Okay. Whitney Morrell. I'm sorry, you want me to recall?
James Barr.
I'll recall James Barr.
Thank you, Your Honor.
James Barr, Judge, I think according to the doc, it shows like he bonded.
It's news to his lawyer.
Not mine. But to my knowledge.
Okay.
Okay, thanks, Judge.
That's what I'm being advised by the deputy. I don't know
Alright.
confinement status.
All right.
Great, thank you.
Okay. Whitney Morrell. Let's
Paul
go.
Ryan, sorry, Your Honor.
Okay. Ms. Morrell, good morning. I find probable cause to believe you should be held to answer for an additional charge of obtaining property over $300 by fraud. Bond in that case is an additional $750, along with all the other bonds that have already been noted in your case. All right. Ebisenith Perez. All right. Ms. Perez, I find probable cause to believe you should be held to answer for one count of distribution of heroin. Bond in that case is set in the amount of $50,000, and also one count of using a two-way communication device to facilitate a felony. Bond in that case is set in the amount of $5,000. In the event that you are released, you post the monetary bond. The defendant shall with your surety bond, it has to be fully collateralized. The net asset value of the collateral must be in an amount equal to or greater than the bond amount. Any property used to collateralize the bond shall not be further encumbered or liquidated during the pendency of the bond. The surety shall provide to the state an updated title search within 10 days of the defendant's release, reflecting recorded mortgages on the properties utilized for bond collateral. The defendant will be monitored by pretrial services. Do you work?
Yes, ma'am.
All right, I'll make it a level 2. You'll have to provide them with a schedule of your working hours and any other necessary absences from your home. And the defendant will not, and that'll be with the GPS, and the defendant will not possess any firearms.
Not only does she work, Judge, but Ms. Perez has been a resident of South Florida for 30 years. She has extensive family here, including her mother, her husband.
Oh, good, then they should be able to postpone.
No,
and
I don't know that they're going to be able to make $50,000, though, Judge.
All right, you're going to have to take this up with the division judge. Thank you.
Your Honor?
All right, yes?
Just, not in this case, just to advise the court, the Spanish interpreter is present.
Okay. Given the amount of cases, I think we'll just have to try to keep her. If we lose her, then we'll get her back at the end. How's that? I'm not starting to look through and all different cases.
I just wanted to let you know.
Thank you. All right.
Your Honor, although normally, like, there's a call out, so if anybody needs to return to the cases, we'd be happy to return once you're...
Absolutely. Let's do it that way today since there's a ton. Okay? Thank you. All right. Shatara Brown.
She's approaching Judge here at Maine.
Thank you. All right, Ms. Brown, I find probable cause to believe you should be able to answer for 3 alleged violations of probation. 2 of them are misdemeanors, and 1 is a felony. The misdemeanors, they all result from 2016 cases. You'll be going to court on the misdemeanor violations of probation next Tuesday, and you will be going 27th. No, I take that back. It'll next Thursday, and you'll be going to court on the felony, a violation of probation on the on Tuesday. All right. So until then, there are no bond holds on you. Margareta Martin.
Miss Martin, come on up, please.
All right, Ms. Martin, I find probable cause to believe you should be able to answer for an alleged violation of probation in a 2013 case. You will be going to court on that on August 1st at 9 a.m. There's a no bond hold on you for that. Tony Zamir.
Miss Zamir, she's approaching, Judge.
Thank you. All right, Ms. Samir, I find there is probable cause to hold you to answer for an alleged violation of probation in a 2016 case. There's a no bond hold on you, but you will be going to court in division on July 26th, which is next Wednesday at 8:45 a.m. Julie Marwa.
Medical loan, Judge.
Med reset. Jennifer Siasia, or Scazia.
Judge, she just stepped out to use the restroom.
All right, I'll pass
She'll be back momentarily.
Shakardra Robinson.
North Broward, Judge.
Did she bond?
No, she's in North Broward.
She's here.
Okay.
No problem.
Thank you. I'm here. What are her priors? Does she show up in court?
Your Honor, I'm showing,
All right, Ms. Robinson, I find probable cause to believe you should be held to answer for the charge of grand theft, more than $300, less than $5,000, also uttering a false instrument. They're checking your criminal history.
I see a theft from 2011. That's all I have, Your Honor.
Okay. All right, ma'am. I'm willing to place you into the pretrial release program. Make sure you follow all the conditions. Be able to verify everything?
No, we were not able to verify any information.
All right, that'll be subject to verification. And make sure you follow all the conditions. Once that's verified, you'll be released. And again, make sure you follow all the conditions or you'll end up back where you are and you won't be getting out as easily. All right?
Yes.
Okay. Sandra Hall.
No problem.
I'm there. All right. All right, good morning, Ms. Hall. I find probable cause to believe you should be held to answer for one count of trafficking in heroin of more than 14 but less than 25 grams. The bond in that case is $250,000. Yes.
Just to advise the court, Ms. Hall is currently out on bond for grand theft, and it looks like she's out. She didn't have to post a bond, but there's also an additional count of child contributing. Oh, no, I'm sorry, just grand theft, Judge.
All right, I'm going to go ahead and revoke bond on that case and place that on a no bond
And it's
status.
case number 165312, CF10A.
Noted.
Yes.
All right, Therese Williams.
Come on.
What?
No problem.
Okay. All right, Miss Williams.
Hi.
1 second.
Your Honor, for the record, count 3 was no info
On who?
for Trace Williams.
Okay, so there's no felony on that one then?
No, just count 3.
So, no, what I'm saying, there's no capious felony for that one, because it was no infoed?
Yes, Judge.
All right, thank you. All right. First of all, Ms. Williams, I find probable cause to believe you should be held to answer for an alleged violation of a municipal ordinance allegedly soliciting for prostitution. Bond in that case is set in the amount of $500. Or it's set, yes. Also, there are three no bond holds on you for alleged violation of 3 different 2017 felony. I'm sorry, there's 2 felony violations of probations resulting in 2 no bond holds on you in 2 different 2017 cases. And there's also a capious for not coming to court on a 2017 misdemeanor. Bond in that case is set in the amount of $100. So total bonds in your case are $600. But again, you're going to be going to court on those felony capiouses for not coming to court. All right?
I don't have a prostitution charge.
All right. You do. It's soliciting.
They never.
All right, ma'am, that's the least of your problems, all right? But you're being held because you didn't come to court for 2 felonies. Okay? Liliana Temescu, that concludes.
Judge.
Yes.
Whenever you're ready, we have Jennifer Sia
Okay.
that was on
Okay.
recall.
Jennifer Scazia?
How do you
pronounce?
Shasha?
All right, Ms. Shasha, I do find probable cause to believe you should be held to answer for an alleged violation of community control in a 2016 case. There's a no bond hold on you for that, and you'll be going to court on August 1st at 9 a.m.
Good luck.
Liliana Temescu?
I've been informed she bonded.
Bonded, correct. Amber Dixon?
She's approaching.
Thank you. All right, Ms. Dixon, I find probable cause to believe you should be held to answer for an alleged violation of probation in a 2014 case. There's a no bond hold on you for that, but you will be going to court on August 15th at 8:30 in the morning. Lakeisha Taylor.
I've been advised Ms. Taylor's a medical reset, Judge.
Thank you. Dana White, I didn't write it. Okay. I should write 24 hours on that?
Just get set for the next day for a medical reason.
All right, Ms. White, I find probable cause to believe you should be able to answer for one count of selling heroin within 1,000 feet of either a place of worship or a park or a church. That is a place of worship. Bond in that case is set in the amount of $7,500, and also a second count of selling heroin. Same situation, $7,500. Total bonds in your case are $15,000.
The defendant is currently being supervised by pretrial service in the following cases: 17-2191 CF10A, sale of heroin within 1,000 feet of place of worship; 17-5196 CF10A, delivery of heroin within 1,000 feet of place of worship; and 17-5817 CF10A, sale or delivery of heroin within 1,000 feet of a place of worship. Based on the court's finding of probable cause, we ask that her pretrial status be revoked on those cases.
All right, I'm going to go ahead and revoke your pretrial release status on those cases, and it's going to be no bond at this time. Idella Brady.
Ms. Brady is here, present, Judge at Main. She is approaching.
Thank you. All right, Ms. Brady, I find probable cause to believe you should be able to answer the charge of interfering with custody of a minor, also resisting or obstructing an officer with violence. Does she have priors, and does she come to court?
Checking that right now, Judge.
Thank you.
Also, Judge, it seems to me this is more of a resisting arrest without violence. The officer does not indicate that at any point in time he was struck.
Wait. I think that's only relevant for purposes of this hearing. Well, based on what I read, I think it's close, but it was probably enough. But let's find out what her priors are. If I do set a bond, that will be reflected in the amount of the bond.
Trespass, resisting without violence, 2015. End of record.
Okay. All right, ma'am, I'm going to place you into the pretrial release program. And just make sure you adhere to all of the conditions, all right? And go to court when you're supposed to, call in when you're supposed to. And in the event, I don't want her having any contact with the child that this all took place about. And did somebody have
Chuck, the only thing I'd ask you at this time is if your order could be reviewed. My understanding is there's probably going to be a dependency action instituted, or I think there currently is one. If that dependency judge goes ahead and imposes some sort of
I was going to say
plan,
until further order of court.
Thank you.
And I don't have
All right,
the initials,
what are the
but
initials
I don't
of the
have
child?
the initials, but I think if you just order no contact with the child that was the subject of this incident, I think that would be
the child that was the subject of this particular incident. You're not to have any contact with that child until further order of court. All right?
Thank you.
Is that standard pretrial?
Standard, thank you.
No bond necessary.
No bond necessary. Kentia McClendon.
I've been informed she bonded.
Thank you. Ethan Dargon.
He's in Conte, Judge.
Thank you.
I'd like to resolve this if possible.
Okay.
Been in jail since May.
What else is he being held on?
He's resolved everything else, Judge.
Okay. All right. Mr. Dargon, your attorney's indicated you'd be interested in resolving this matter today. If you want to close this case out today by pleading no contest, I will take note of your time in jail in lieu of court costs. If not, you're going to have to post bond in the amount of $1,000 and remaining, and if you don't, you'd remain in custody while this case was being resolved through the court system. So do you want to resolve it today by pleading no contest?
Judge, he posted bonds.
Yes, Judge.
Bond was posted?
Bond was posted. So if I just want to make sure he's advised. If he doesn't want to resolve the case, he's going to be released. He posted.
You're going to be released either way. Apparently, somebody did post a bond for you, so that will allow you to go through the court system. So you could be released on that. Or again, if you just want to resolve it, so you don't have to go to court anymore, you could do that too. It's totally up to you. What do you want to do?
Yeah, I want to resolve it.
All right. Plea of no contest as ordered. Okay. All right, you'll be released today. Good luck. Curtis Trailer.
North Broward. He would also like to resolve this.
Yes, I'm withholding adjudication on all the pleas that I take. All right, and I had made a note to resolve this. All right, Mr. Trailer, this is an additional charge that they found on you for failing to obey a police officer. If you want to resolve this case today by pleading no contest, I will take note of your time in jail in lieu of court costs and withhold adjudication. If you don't want to do that, then you're going to have to post bond in the amount of $250, or you would remain in custody while your case is being litigated. You want to resolve it?
I want to resolve it, but I just wanted to make sure all my ad charges.
This is the ad charge.
So there's no more charges.
He's got another case that he was ROR'd on.
There's another case, but you were released on your own recognizance, so you will be getting out. So you'll be going, it sounds like you'll be going to court on one charge. And yeah, you look familiar. Okay, right. All right, so you're going to get released now. This was your only other charge. Okay?
Thank you.
All right. Mohammed Balouz.
No problem.
All right, good morning, Mr. Balouz. I find probable cause to believe you should be able to answer for one count of a misuse of the 911 emergency system. Bond in this case is set in the amount of $100. Does somebody know you're here, that in jail?
No, ma'am. I'm from Chicago.
You're from Chicago?
Yeah, visiting.
All right. You're going to have to post bond. Thank you. Cleveland, Shropshire. I'm going to resolve this if he wants.
Judge, Mr. Shropshire is here, President of Maine.
Thank you.
Wishing to ask the court if you would consider resolving his case.
Yes, I was going to make him an offer. All right, Mr. Shropshire, if you wish to resolve this case today, state you weren't seeking any additional time or jail, were you? Okay.
No, Judge.
Did you say no? I'm sorry.
I said no, Judge.
Okay. All right, if you want to close out this case today by pleading no contest, I will take note of your time in jail in lieu of court costs, and I'll withhold adjudication. And if you don't want to accept that, you're going to have to post bond in the amount of $500, so you'll remain in custody until your case is finished being litigated. So do you want to resolve the case today? No, don't. Leave the buttons alone. You just turned it off.
Now you're on. Yes, I accept that.
Okay, so ordered. Okay.
You're done. Thank you.
Okay. This is Aaron Payne.
Mr. Payne is here, President.
Okay. All right, Mr. Payne, I find probable cause to believe you should be able to answer for an alleged violation of probation on a 2016 case. And the bond on that case is $15,000. It is a misdemeanor. $15,000 on a misdemeanor.
It's a VOP. I mean, it could have been no bond.
It says misdemeanor, VOP, MISD, and it is set in MA. Who's MA?
Judge Brown.
And it is, I believe, a 2010 case, Judge.
And it also looks, well, it's a 2010 case. He got probation in 2016.
Okay, this was a VOP.
He's driving again.
Or driving on a revoked
2 months after getting
a DUI. 12 months probation.
And he apparently dirty urine.
Yeah, no, there is a lot. There is a lot here. I'm not. It's a 2010 case. Do you have anybody? I would be willing to lower your bond to $1,000. Do you have somebody who can post that for you?
Yes, I do.
Okay, I'm going to lower it to $1,000.
Thank you, Judge.
Okay. Roderick Wheeler.
Mr. Wheeler, come on up, please. He's approaching.
Yes.
Mr. Wheeler, come on.
All right, Mr. Wheeler, I find probable cause to believe you should be able to answer for one count of petty theft, supposedly a second offense. You're also charged with committing a theft or resisting the merchant, another count from another day, or the same day, I believe, of, but another food item. Was this 2 different days? I'm sorry, I want to be exact. Yeah, same day.
Judge, Mr. Wheeler advised me.
Okay. What are his priors, and does he have a history of not coming to court? And also another count of resisting the merchant. And regardless of how you're released, if you are to stay away from the Publix at 2501 East Sunrise.
Just pled out 2 counts of theft in May of this year.
Did he come to court?
That's what I'm checking.
Okay.
He was arrested in 2006 on a failure to appear, again in 2006 on a failure to appear. I'm getting hits out of New Jersey, California.
All right, sir. As far as the first count of petty theft, bond in that case is set in the amount of $500. Resisting a merchant, bond in that case is $500. Another count of petty theft, bond in that case is $500. Resisting will be an additional $100. Total bonds in your case will be $1,200. Do you have somebody you can call?
Nobody.
Thank you.
No family.
All right, Jamil Rakelmi.
Mr. Raquelman is approaching, Judge.
All right, Mr. Rakelmi, I find probable cause to believe you should be able to answer for a petty theft. And nobody can post your $25 bond?
Do
you need
my mom's on the way up to New York right now on a plane, so I'm gonna have to wait for that. So,
all right,
is there any...
let me. Does he have any priors, and does he come to court if he does?
Looks like prior arrests that were all dropped.
Okay. All righty, I'm going to place you into the pretrial release program then, or you can wait and get a hold of your mom. Or do you have a friend who can go post $25 for you? I'll give you access to your phone.
The only number that I know is my mother's number. That's the only number I know by heart.
Well, that's why I said I'll sign an order giving you access to your phone. Do you have a phone?
Is your phone in property?
No, I don't. I don't have
okay.
a phone, no.
All right, sir. Then I'll place you into the pretrial release program. Make sure you adhere to the standard conditions. Otherwise, you'll end up back where you are and not get out as easily.
Does he have a permanent address?
Do you have a permanent address, your mother?
Yes, I do.
Okay.
Yes.
What is that address?
Pending verification. You want him to state it on the record? What's the address?
I'm sorry. Does the court want him pending or?
9149H Southwest 21st Court.
Okay.
I'm sorry, I was listening to the court and not to him.
Okay, so pretrial's asking me a question.
Is the court releasing him outright or is he pending verification? Okay. Now, for the record, his address.
Okay, now your record.
Now your address.
Your address, I'm sorry.
9149H Southwest 21st Court, Boca Raton, Florida.
Is that a house or apartment?
That is a house. It's a townhouse.
And the zip code, please?
Zip code.
33428.
Your Honor, if you could just instruct him that he must report to pretrial, if not today, then between 8 and noon on Monday morning. Failing to appear will result in a warrant for his arrest.
All right, did you hear that? You have to report to pretrial. It could result in arrest by Monday morning. If you don't do that.
Follow it as soon as you get released today.
Thank you.
All right.
It's gonna be here.
Yeah.
Like
It's across the street. Okay. And if you get released too late tonight, you have to be there Monday morning, first thing in the morning. All right.
So there's a chance to release today.
Yeah, you're gonna be released.
Sean Sampson.
Mr. Sampson.
All right, Mr. Sampson, if you want to resolve your case today of possession of cannabis, it's a 2013 case, I would take note of your time in jail in lieu of court costs and withhold adjudication, or you can post a $5,000 bond and remain while your case is litigated. What
Judge,
would you
you're
like to
cutting
do?
in and out again.
I have it all the way up, so you need to turn yours up or down.
No,
and-
I have no way of turning mine up. Every time you like lean back, I guess
okay.
the audio goes out.
All righty. All right. If you want to resolve your case today by pleading no contest, I'll withhold adjudication, take note of your time in jail in lieu of court costs, or else you can post $5,000 and remain at liberty while your case is litigated. What would you like to do?
Let the judge know.
Do you want
Let the
to?
judge know you want to resolve the case.
Resolve the case.
Okay, plea of no contest, so ordered. Alex Jean.
Good morning.
All right, thank you. All right, Mr. Jean, I do find probable cause to believe you should be able to answer for resisting or obstructing an officer without violence. Also, you are charged with trespass of the structure. Okay, if you want to resolve this case today by pleading no contest, I will take note of your time in jail in lieu of court costs. Otherwise, you can post a $100 bond. I'll ROR you on the second charge. So do you want to post a bond and go through the court system at liberty? Do you want to stay in jail, or do you want to resolve the case today by pleading no contest?
Resolve the. I pleaded no contest.
Okay, so ordered. Talvin Johnson.
Mr. Johnson's here present, Judge?
All right, Mr. Johnson. Okay, 1 second. I was making notes. All righty. Mr. Johnson, if you would like to resolve both of these cases today by pleading no contest, I will take note of your time in jail in lieu of court costs unless the state tells me they're looking for additional time.
Yes.
Okay.
Calvin Johnson, one moment, Judge.
Yes, I'd like to resolve my case.
All right, well, I'm just checking with the state to see if they're seeking additional time or not. I mean, he does have, looks like he has an extensive criminal history.
Yeah, I'm just, and frankly, I'm just making sure that there's no restitution issues.
All right, that's fine.
No, Your Honor, I'm fine with the court open.
All right.
Open plea.
Okay, so if you want to plead no contest to both charges, I'll take note of your time in jail in lieu of court costs and withhold adjudication. Or else you can post $1,000 total in bonds in this case and remain at liberty while your case is being litigated. What would you like to do? Close it out?
I'd like to resolve, yeah, close it out.
All right, so ordered. Have a seat.
All right.
Stevie Jenkins.
Mr. Jenkins is approaching his hero man.
Okay. All right, Mr. Jenkins, I find probable cause to believe you should be able to answer for not coming to court on a trespass case. If you want to resolve this case today by pleading no contest, I'll take note of your time in jail in lieu of court costs and withhold adjudication, or else you can post $500 and remain at liberty while your case is being litigated, or I guess you can stay in jail until it's resolved. What would you like to do? You want to resolve your case?
Yes, ma'am.
Okay, so ordered. Jose Mendez.
Mr. Mendez requires a Spanish interpreter, Judge.
All right, I will pass that case to the end of the docket when we get the Spanish interpreter back. Whitley Oliver.
Been informed he bonded.
Okay, thank you. Robert Jones.
Mr. Jones is here present, Judge. He's inquiring if his bond's been posted already.
All right. There's been an indication of no. All right. Does he have a history of not coming to court?
1 moment, Judge.
Yeah, he does on this case. Sorry. And he has another misdemeanor, it says right here. All right, Mr. Jones, bond for I find probable cause for the driving with the suspended license, first offense. Bond in that case is set in the amount of $100. And also there's a capias fee not coming to court on another I believe it was driving with a suspended license. Yes. I'm going to set bond in that case also in the amount of $100. Total bonds in your case are going to be $200. So who's ever posting it for you, it's going to be less. All right?
Thank you, Your Honor.
Okay. Alexander Marino.
North Broward.
All right, Mr. Marino, I find probable cause to believe you should be held to answer for one count of touch or strike battery. Priors, and does he come to court?
Yeah, Mr. Marino's been through here
Okay.
a lot.
All right. Would the state, I would, if the state wouldn't object, I would make him an offer to resolve the case and reserve to restitution, order restitution reserved to an amount, if any.
Well, I would object to a resolution of a battery, Your Honor.
Okay, that's fine. All right. Does he have a history, though, of coming to court, or he misses court?
I always come to court.
All right. If we can verify that, then I'll place you in pretrial.
I appreciate it.
Okay.
Is that it?
No.
hang on, man.
Don't you want to find out what's going to happen?
Yes, I did.
Yes.
All right.
Didn't he have
They're
a
checking.
previous aggravated battery?
That's well.
No, this is straight battery.
No,
Simple
he has a
battery.
previous, Your Honor.
But does he come to court?
But, Judge, I'll check. But also, if he doesn't, it might be qualified because I know he's been here a lot, and in a lot of cases he doesn't bond out. So he resolves his cases. He never had an occasion where he's been out of custody where he had to show up in court.
He was released from Florida State Prison 2015 for a burg dwelling. Occupied burg dwelling, and then after his release, he had the ag bat in 2016.
The burglary was on my mother's house.
All right.
Don't say anything.
It's okay. Don't say anything.
I can't tell you, Judge.
If nobody can tell me that he doesn't come to court, then I'm going to place him in pretrial.
Well, Judge, I can't tell you.
You can't tell me either way, State? Is that
No,
what
I can
you're
tell
saying?
you what I can tell you, and I think it's relevant, is it seems like every time he's on probation, I see him violated numerous probations, which tell me he doesn't follow conditions, and he's still going to have to be on conditions. If
All right,
he's
Mr.
on
Marino, you're going to have to post bond, but I'm going to lower it to $500. Is there somebody who can post this bond for you?
As of today, I don't know.
All right. Do you need access to your phone? I'll be happy to sign in order to give you access so you can call somebody. Do you have a phone and property?
I'm homeless.
You're homeless. All right. Bond set in the amount of $500.
Judge, I'm going to ask you to sign an order allowing our office to photograph Mr. Marino's injuries. I think it's pretty clear just looking at him on the screen there. He's got some...
Okay. Are you injured, sir? I don't see any injuries. I see a beard, but you might have a better picture than I.
Yeah, I think I'm burned.
You're burned?
Yeah.
Okay. I'll sign an order.
Thank you, Judge.
You know, we'd ask for an order of no
Can I go to the hospital?
no victim contact.
Okay. A determination will be made not by me. In the event you are released, though, you are not to have any contact with Nathaniel Shull. Okay?
All right.
Tarval, Ware?
Mr. Ware's here at Maine.
All right, Mr. Ware, if you want to resolve your case today by pleading no contest, I'll take note of your time in jail in lieu of court costs and withhold adjudication. If not, you can post a $25 bond and remain at liberty while your case is being litigated, or you can just stay in jail. It's up to you. You want to close it out?
Resolve, please.
All right, so ordered. No contest. Andres Pena? All right, Mr. Pena, you speak English?
Yes, ma'am.
Okay. I find probable cause to believe you should be held to answer for the charge of trespass of property, not a structure or conveyance. If you'd like to resolve this case today by pleading no contest, I will withhold adjudication and take note of your time in jail in lieu of court costs. Or you can post a $25 bond, remain at liberty while your case is pending, or you can stay in jail. Do you want to resolve your case today?
Yes, I want to resolve my case today.
All right, so ordered. Plea of no contest. Woodrow Blunt.
Thank you.
Okay.
Mr. Blunt, come on up, please.
I did call it
Private
first,
counsel
but
here
you
for
weren't
Mr.
here.
Jones.
I called it, but you weren't here. All right. All right, Mr. Blunt, I don't have the, an affidavit of violation of probation, but I do see that he's on probation.
Your Honor, it's a
And the
948. It's a 940.
Right, but you still need probable cause to hold.
That's not, Bill.
What?
I'm
Okay.
responding to what the judge said about that. I mean, I understand, but
It doesn't matter if it's 9:40.
Okay, don't interrupt, Miss.
you're not going to have an affidavit because it was a warrantless arrest, Your Honor. It was
Okay.
based on the allegations in the probable cause affidavit.
There is, one second. Okay. Okay. Okay, let me read this. Why wasn't he charged with these crimes? Possession.
Frankly, I don't know, Your Honor, but because
There's a number of crimes it seems like he could have been charged with.
and Your Honor,
But I don't understand why they apparently had a search warrant, contraband was found. There's no indication, alleged contraband was found, and it was tested positive, and it's reflected he's on probation, but there's no violation followed. This is a little, am I
Your Honor,
wrong? It's a little unusual.
I would imagine the reasoning is because, and that's why what they specifically state is not that he can't be in possession of any drugs. He cannot be around any drugs or illegal activity, Your Honor. So even if he wasn't in possession, he can't be around it. That stuff's in his room. And that's why they specifically mentioned they spoke with the probation officer to verify that stipulation, that condition of probation.
Please.
So they spoke to probation. Again, there may be more to this, but this affidavit is woefully inadequate and even a lower standard for probation. So again, it doesn't say how. It said it
No, I agree that they executed a search warrant. That's about all we know. We don't know where he was found in the unit. If it was a 2-bedroom apartment, was it his bedroom? This is really specious. I'll give the state 24 hours to perfect.
Your Honor, I would just know for the record, he obviously was at the apartment. That's where he was arrested.
I understand that, but there's nothing in the affidavit connecting him with the drugs.
I understand, Your Honor. I'm just responding to your Honor stated as one of your reasons that he wasn't. We don't know if he was there, and I'm saying he was.
No, I didn't say that. No, he was there. He was there, but there's nothing indicating him there's nothing connecting him with where the drugs were found. It's a very vague affidavit. I'll give the state 24 hours to perfect.
So procedurally, does that mean it'll be on the docket tomorrow morning?
Yes.
Okay, and who's the judge? Just so I know.
Judge Frink, Keith and Frink. Okay. All right.
Did you order Mr. Linder to be here, Judge?
No.
That was a joke.
Does my influence extend that far?
For the record, we all love Mr. Linder.
Yes,
He's
we do.
always, diligent.
Yes, he does. Okay. All right, Joseph Ramsing.
I've been advised it's a medical reset.
Okay. He had a med reset yesterday. Let's see if he can come up tomorrow. It should be resolved. Mark Cabral.
Yes.
All right, Mr. Cabral, I find probable cause to believe you should be held to answer for an alleged, one second. There's an arrest warrant on you for felony petty theft. Bond in your case is set in the amount of $750. You're gonna have
Judge,
to
I
post
think
that.
this is a felony petty.
Yes.
theft. Okay.
Okay.
It's the only charge holding him.
Right, it's an
Right,
arrest
Mark?
warrant holding him.
Okay.
Okay. Robert Anthony.
Also in contact.
All right, Mr. Anthony, I find probable cause to believe you should be held on an additional charge. They found there's an arrest warrant for you for a 2017 case for grand theft. Bond in that case is set in the amount of $1,000. That's in addition to any of your other bonds. All right?
Judge, I think he also has, Mr. Anthony, don't go anywhere
Mr.
yet.
Anthony,
I think he also has another third charge, Judge, where no bond has been set.
I think this was 3.
Can I just have 1 second just to check?
No, this was count 2. An additional or not count 2, this is an additional charge.
Your Honor, he should be here for counts 1 and 2. Count 1 is a hold for magistrate.
Did she set the bonds right?
Count 1 is a hold for me?
Yes.
And
Where does it
what
say
was the
that?
bond?
Yeah, it is count 1 as a change of charge, and a bond has not been set on that.
Your Honor, bond was originally set at 5,000. I just asked that it be reset at 5,000.
Okay. All right, I'm going, as to count 1, there's a change of charge. So now what is he being charged with?
Burglary of an occupied dwelling.
All right, on the burglary of an occupied dwelling, your bond was before you were charged unoccupied?
Yes.
Okay, it's your.
Oh, all right, well. Okay.
It's kind of being like upfiled a little bit, but I'll leave your bond at the same amount. There's a $5,000 bond for that charge, burglary of an occupied dwelling, and your additional charge is $1,000. So the total bonds in your case are now $6,000. Valari Boyd.
Mr. Boyd, that's a call right.
Thank you. All right, Mr. Boyd, I find probable cause to believe you should be able to answer on an additional charge of a
This is here because we did a change of charge.
looks like felony petty theft. But then I don't have his priors, so I don't actually know that.
1 moment, Your Honor.
And in the event you are released while the state's researching this for me, you are to stay away from the Walmart at 5555 West Atlantic Boulevard in Margate.
Your Honor, I'd ask the court to take judicial notice. 3 of the counts he's being held on are for probation violations for felony theft.
Okay, thank you. All right, bond in your case is set in the amount of $750, sir.
So I can't resolve this?
No, you cannot. Gene Joseph. All right, Mr. Joseph, I find probable cause to believe you should be able to answer for an additional charge of criminal use of an ID. Bond is set in that case in the amount of $1,000, and that's in addition to any of your other bonds. Michael Anderson.
Mr. Anderson's approaching, Judge. Decline the services of the public defender.
All right, Mr. Anderson, you don't want to have this. You don't want to have the services of the public defender this morning.
No, ma'am. But I asked you, can you please court order me this out?
Can well, I can do that if somebody posts. No, I can't do that. But I will tell you, I find probable cause to believe you should be held to answer for 1 count of possession of PVP. Bond in that case is set in the amount of $1,000. There are 3 no bond holds on you for not coming to court on 3 different 2000. Actually, it looks like two different felony cases.
I have 3 cases.
Okay, 1 second. Okay, 1 second.
Everything but count 8, one way or another, has already been dealt with. The only thing for the court's review today is
I'm sorry. All right. You haven't. Okay, that's correct. All right, Mr. Anderson, you've been previously magistrated on counts 1 through 7. The only charge that I'm going to magistrate you on this morning is and I do find probable cause to have you held on burglary of an occupied dwelling. I'm going to set bond in that case in the amount of $5,000. That's in addition to any other holds on you and the $1,000 bond for possession of PVP. And no, I'm gonna deny your motion to be put into SAP at this time. You could take that up with your division judges. Demetrius Wilson.
Mr. Wilson is approaching, Judge.
All right, Mr. Wilson, I find probable cause to believe you should be able to answer for 1 count of distribution or delivery of heroin. Bond in that case is set in the amount of $25,000, also using a 2-way communication device to facilitate a felony. Bond in that case is set in the amount of $5,000. Total bonds in your cases are $30,000.
And Your Honor.
Thanks, Judge.
Well, Your Honor, Judge Uson also said special.
Okay.
Can we have him come back, please?
Yeah, please come back, Mr. Marcus. I guess all of these have the same conditions. I will read them into the record. All right, in the event you do, okay. All right, Mr. Wilson, in the event you do post bond in this matter, the surety bond that you post has to be fully collateralized. The net asset value of the collateral must be in an amount equal to or greater than the bond amount. Any property used to collateralize the bond shall not be further encumbered or liquidated during the pendency of the bond. The surety shall provide to the state an updated title search within 10 days of the defendant's release, reflecting recorded mortgages on the properties utilized for the bond collateral. The defendant will be monitored by pretrial services. Do you have a job, a regular job?
I'm supposed to start next week, man.
Okay.
Okay, I'm here.
All right, that would be, well, is somebody going to post $30,000 bond for you? All right.
No, ma'am, it just
Okay, the defendant will be monitored by pretrial services, I'll say level 2 with a GPS, if he has a schedule of places he needs to be. And also, during the pendency of this matter, you shall not possess any firearms. All right? Patrick Sylvain.
Mr. Sylvain, come on up. Mr. Sylvain, it's your
All right,
present, Judge Germain.
Mr. Sylvain, I find probable cause to believe you should be able to answer for one charge of trafficking in heroin more than 4 grams but less than 14 grams. Bond in that case is set in the amount of $250,000. Also, use of a two-way radio in order to, or communication device in order to facilitate a felony. Bond in that case is set in the amount of $5,000. In the event you are released on bond, the surety bond has to be fully collateralized. The net value of the collateral must be in an amount equal to or greater than the bond amount. Any property used to collateralize the bond shall not be further encumbered or liquidated during the pendency of the bond. The surety shall provide to the state an updated title search within 10 days of the defendant's release, reflecting recorded mortgages on the properties utilized for the bond collateral. The defendant will be monitored by pretrial services, and during the pendency of this matter, you shall not be in possession of any firearms. Do you have a job? Regular job?
the job is seasonal, though.
Okay. All right, so it's going to be pretrial level 2 with a GPS for any necessary absences from your residence. I like to go to school, pick up kids, go to the doctor, things like that. All right, you have to provide a schedule to the pretrial release people if you are released.
Judge, if the defense could be heard, speaking to Mr. Sylvain, he advised me he's 24 years old, been residing in our community his whole entire life. At this time, he's actually looking for more stable employment. He only has seasonal work. He lives in Pompano with his mother. He's been residing in the same location for his whole life. If the state can confirm, my understanding is he's not a convicted felon. I believe the last time he got arrested was approximately 5 years ago. Judge, considering his lack of serious criminal history, strong ties to community, he attended Deerfield Beach High School, would you consider reducing his bond from $250,000 to something more attainable, somewhere along the lines of $25,000?
I would lower it to $100,000. That's about as low as I would go.
Yes, Judge. Thank you.
So now your total bonds are $105,000 plus the special conditions previously stated.
Yes, Judge.
Jim and Williams.
Mr. Williams is here present, Judge.
All right. All right, Mr. Williams, I find probable cause to believe you should be able to answer for the charge of trafficking in heroin of more than 4 grams, less than 14 grams. Bond in that case is set in the amount of $250,000. Also, use of a two-way communication device to facilitate a felony. Bond in that case is set in the amount of $5,000. In the event you are released on bond, the following special conditions are going to be imposed. Any surety bond that is posted has to be fully collateralized. The net asset value of the collateral must be an amount equal to or greater than the bond amount. Any property used to collateralize the bond shall not be further encumbered or liquidated during the pendency of the bond. The surety shall provide to the state an updated title search within 10 days of the defendant's release, reflecting recorded mortgages on the properties utilized for the bond collateral. The defendant shall be monitored by pretrial services, and the defendant shall not possess any firearms during the pendency of this matter. Do you have a job? State.
Yes, ma'am.
Or 1 second.
Even with Mr. Williams saying that he has a job, he'd still be asking for level 1. His criminal history, 2010, trafficking in oxycodone between 14
All right,
and
noted.
20.
All right, sir, in the event you are released, you're going to be placed on a level 1, which is basically house arrest and being with a GPS monitor.
Mr. Judge, if I could be heard, in speaking with Mr. Williams, I know his bond right now is $255,000. He's 36 years old, been living here
What
his whole life.
about the traffic in oxycodone
That's real.
charge from before? He has a serious prior.
Right, I never said he didn't.
Oh, okay.
Yeah, I never said he didn't. I just said he's been residing here his whole life, Judge. He's working for a landscaping company, so he does have a little bit as far as money. He makes $480 a week. He lives with his aunt and his wife. He's been married for 3 years, has 3 children. His aunt works at Publix, and his wife works at a doctor's office. $250,000 out of his reach. I would actually consider lowering it to $100,000.
Okay, all right. The state has indicated he hasn't lived here his whole life.
Yes, I have.
My point is, there was 5 years he was sentenced to prison in 2000 for sale, delivery of cocaine within 1,000 feet of the place of worship.
We can't hear the state.
Okay, they can't.
He was sentenced to 5-year state prison in 2000 for sale, delivery of cocaine within 1,000 feet of the place of worship. And as I mentioned, 2010, he was sentenced to 40-month state prison. You're not residing in South Florida when you're sentenced to state prison.
Okay. All right. All right. Let's say he's domiciled in South Florida.
My point is, though, Your Honor,
all right.
with those priors, I'd ask that the bonds be kept in place.
All right. I'm going to leave the bonds as it is. Of course, your attorneys can make application to the division judge for a reduction in the bond. Okay, and any other conditions of release. Jeremy Farrington.
Mr. Farrington's here, present, Judge. He declined to serve as the public defender.
Mr. Farrington, you don't want to be represented by counsel this morning?
No, ma'am.
Do you have your own attorney?
Yes.
Does your attorney know you're in jail?
Yes, ma'am.
Okay.
I didn't make it.
Is your attorney a public defender?
No, ma'am.
Okay. Did your attorney tell you to let the judge magistrate you, or?
He didn't. I didn't really get a chance to reach out.
Oh, you haven't been able to call him?
No, ma'am.
I can reset your hearing today, and I would sign an order permitting you access to your phone if you want to contact him before you have this hearing, or else we can just proceed with the hearing.
Yes, you can proceed, ma'am.
All right. I find probable cause to believe you should be able to answer for trafficking in heroin of more than 4 grams, less than 14 grams. Bond in that case is set in the amount of $250,000. Also, use of a two-way communication device in order to facilitate a felony. Bond in that case is set in the amount of $5,000. Total bonds in your case are $255,000. In the event bond is posted for you, sir, and it would have to be pursuant to a surety bond that is fully collateralized. The net asset value of the collateral must be in an amount equal to or greater than the bond amount. Any property used to collateralize the bond shall not be further encumbered or liquidated during the pendency of the bond. The surety shall provide to the state an updated title search within 10 days of the defendant's release, reflecting recorded mortgages on the properties utilized for bond collateral. The defendant will be monitored by pretrial services. Are you working? Do you have a regular job? Where do you work?
Yes, ma'am.
Where do you work?
Lamb's Landscaping.
Okay. All right, then that would be, does he have extensive prior state?
I'm showing a, 1 moment, Judge, I just see everything.
And also, while he's looking that up, during the pendency of this matter, you are not to be in possession of any firearms.
Yes, ma'am.
Okay, he's got a pending petty theft from earlier this month. I believe he's out on bond. Additionally,
Okay, I'm gonna go ahead and revoke bond and order a no bond hold on him for that.
case number 176079,
Okay. All right, and you will be monitored by pretrial services. I'll make it level 2, so, okay. You'd have to provide a schedule. He left. Okay. Shenard McCall.
Judge, before we go to the next gentleman, I'm being informed by the deputies if we could call a gentleman out of turn, Mr. Sean Bremser on page 34. So
does that mean
like
towards the end?
Last page? Or second to the last page. Mr. Bremser?
I have a third pile here. Alrighty, Sean Bremser. All right, Mr.
Yes,
Bremser, I find probable cause to believe you should be able to answer for carrying a concealed firearm, also possession of alprazolam, possession of cannabis over 20 grams, also unlawful, oh, that's speeding, okay. What are his priors?
Priors include.
And does he come to court?
Right, well, as far as priors, battery 04, disorderly conduct 04, resisting without violence, loitering and prowling 04, resisting without violence, disorderly conduct 02. As far as
That's the prior to this arrest, the last one was 13 years ago, is what you're telling me?
as far as Broward,
This is Mr. Bremser?
Yes.
We've been advised that his girlfriend posted his bond.
Okay, your bond is posted by your girlfriend, all right?
Your bond was posted, sir. Oh, sir.
Okay.
Thank you. Oh, sir.
Shenard McCall. All right, Mr. McCall, sir, I find probable cause to believe you should be able to answer for trafficking in heroin of more than 4 grams, less than 14 grams. Bond in that case is set in the amount of $250,000. Use of a two-way communication device to facilitate a felony. Bond in that case is set in the amount of $5,000. However, there is also, besides your cash bonds, there's a no bond hold on you for an alleged violation of a 2015 or community control felony case, and you will be going to court on Tuesday at 8:30 on that matter. All right?
You're regarding special conditions?
Okay. Thank you. And Mr. McCall, in the event you resolve your no bond hold, come on back. Mr. McCall, in the event you resolve your probation or community control violation next week and you post your bonds in the amount of $255,000, you're also subject to the following special bond conditions. Any property that is used to secure your bond has to be fully collateralized. The net asset value of the collateral must be in an amount equal to or greater than the bond amount. Any property used to collateralize the bond shall not be further encumbered or liquidated during the pendency of the bond. The surety shall provide to the state an updated title search within 10 days of the defendant's release reflecting recorded mortgages on the properties utilized for bond collateral. The defendant will be monitored by pretrial services and you will not possess any firearms during the pendency of this matter. Do you have a regular job?
Yes, ma'am.
All righty. Then I would order a level. Where do you work?
At Bob's Painting.
Okay. Then I will order you to be supervised by pretrial services at level 2 with the GPS. If you are released and you're going to go to work, you're going to have to provide pretrial with a schedule of all the times you need to be out of your residence for any necessary things like going to work, going to school, picking your kids up, going to the doctor, things like that. All right?
All right.
Christopher Paul.
Mr. Paul?
All right, Mr. Paul, I find probable cause to believe you should be able to answer for aggravated battery with a deadly weapon, one count of tampering with or fabricating physical evidence. What are his priors, and more importantly, if he has any, does he come to court? This was apparently out of a road rage incident.
Your Honor, he has a similar misdemeanor offense as a juvenile in 2015. There are no indications that he does not appear.
Now, you said it was a similar.
Yes, Your Honor.
What do you mean?
Misdemeanor offense as a juvenile.
Tell me about it.
Well, Your Honor, if we go sidebar, we don't want to broadcast the juvenile prior over the internet.
Okay. All right, we're going to go sidebar.
Yes, Judge.
So I want to hear a little more about this young man. Okay. I just pressed the sidebar button, right?
Yeah, that should.
That should do it?
Yeah.
Okay.
We can still hear you, though.
It says, but I think when I press that, it doesn't go over the internet.
Then I guess we could do juvenile again to be safe, but.
Oh. You can hear me though, right? How old are you?
20.
You want to read that? You want to read it to me or get?
We'll tell you, Judge.
Your Honor, it's Eileen Ruiz on behalf of the state. There is a battery from 2013 that went through diversion program, and a 2014 battery, and he received judicial warning.
Okay, so he's got anger management problems. All righty. Okay. So let's go back on. All right. I'm going to place you into the pretrial program. It's going to be, you're working?
Yes.
Okay, it's going to be level 2 with a monitor, which means that you are going to be monitored, and you're going to have to provide a schedule to pretrial of any necessary absences from your residence. Where do you work? I'm sorry?
Teleperformance.
Okay. So you'll have to give them a schedule of any necessary. If you pick up kids from school, if you go to the doctor, things like that, you have to give them a schedule. Additionally, I'm going to order anger management classes for you, sir, while this matter is pending. Okay?
Your Honor, no victim contact?
What?
No victim contact?
Oh, yeah, that goes without saying. And in the event you, and once you get out on pretrial, sir, you are to have no contact with, and I know the name is here, Cody Sagasi?
Yes, Your Honor.
Okay? You're not to have any contact with him, okay?
Yes, ma'am.
Judge, I just want to make sure there's no conflict now. I don't think there will be. He will be attending Broward College in fall, so as long as
He can go to
provides the
school,
schedule
too.
for pretrial.
Absolutely. All righty.
And Your Honor, that's without bond?
No, he's not going to have to post any money. Okay? All righty. Evan Weisberg.
Mr. Weisberg, come on up.
Mr. Weisberg, I find probable cause to believe you should be able to answer for an alleged violation of probation in a 2000, looks like 15 case. There's a no bond hold on you for that, but you will be going to court on that next Wednesday at 8:45 a.m.
Good luck. Yep.
Patrick Robinson.
Ms. Robinson.
All right, Mr. Robinson, I find probable cause to believe you should be able to answer for an alleged violation of probation on a 2016 felony. There's a no bond hold on you for that, sir, but you will be going to court next Wednesday at 8:45 a.m. on that matter.
Good luck, sir.
Peter Giacobelli. All right, Mr. Giacobelli, sir, I find probable cause to believe you should be able to answer for an alleged violation of a 2000, looks like 16. 1 second. 2000, thank you. 2015 felony. There's a no bond hold on you for that, but you will be going to court on July 31st at 8:30 a.m. Efren Cologne. All All right, Mr. Colon, I find probable cause to believe you should be held to answer for an alleged violation of probation in a 2016 case. There's a no bond hold on you for that, but you will be going to court on August 9th at 8:30 a.m. on that matter. Jordinsky Olivier.
Mr. Olivier?
All right, Mr. Olivier, I find probable cause to believe that you should be held to answer for an alleged violation of a 2016 probation case. There's a no bond hold on you for that, sir, but you will be going to court on July 31st at 8:45 in the morning. Adam Dean.
Mr. Dean is here present, Judge. He declined to serve as public defender.
All right, Mr. Dean, you don't wish to have representation this morning?
No.
All right, I find probable cause to believe that you should be held because you violated your pretrial release in 2 different felony cases, but it's written up as 3. And also, so there are now 3 no bond holds on you for those cases that you were released previously into pretrial. And there is also a no bond, there's a no bond hold on you for an alleged violation of probation from a 2014 felony. You will be going to court on August 2nd at 8:30 a.m. for that, actually for all of them. Jason Simeon.
Simeon's here present.
All right, sir. I find probable cause to believe you should be able to answer for an alleged violation of probation in a 2013 case. There's a no bond hold on you for that, but you will be going to court on August 1st at 8:30 a.m. Brian Wilson. Mr. Wilson, I find probable cause to believe you should be held to answer for an alleged violation of your parole, so there is a no bond hold on you for that. Derek Dunbar.
Mr. Dunbar? Derek Dunbar?
All right, Mr. Dunbar, I find probable cause to believe you should be able to answer for an alleged burglary of an unoccupied conveyance. I'm going to set bond in that case in the amount of $3,500. Also, giving a false ID to a law enforcement officer, I'm going to set bond in that case in the amount of $100. But there is a capias out for you that you have a no bond hold on for not coming to court, and that's a 2016 felony case. How is he out of jail on that at the present? Derek Dunbar, possession of that drug I can't pronounce. Okay. All right, well, I'm going to revoke your ROR on that, and...
Your Honor, he's already being, on count 3, he's already being held no bond.
Yeah, I know, but, okay, so you're being held no bond basically because you missed court, okay? And I don't have a court date for you. But if you resolve that, then total bonds in your 2 new charges are $3,600. Celdrick Rucker.
North Broward.
Thank you. All right. Mr. Rucker, I find probable cause to believe you should be able to answer for 1 count of distribution or delivery of cocaine. And bond in that case is set in the amount of $10,000. Just wait, I'm looking to see if there's no special conditions on this one. All right, that's that.
Judge, I can advise the court that Mr. Rucker has lived here in South Florida all of his life. He lives with his parents. He's been
Well, let me
living
find
there.
out about his priors,
All right.
and more importantly, does he have a history of not coming to court?
Okay, Your Honor, his criminal history. 2013 strong-arm robbery, 35-month state prison.
All right, thank you. That's $10,000 bond. Okay. No other special conditions, except that in the event you are released, I'm going to place you on, be under supervision of pretrial level 1 with a GPS monitor. Aaron Moorhead. Yes.
Thank you.
With the bond.
Yes.
Aaron Moorhead.
Moorhead, he's here present, Judge at Maine?
Thank you. Okay, Mr. Moorhead. Sir, I find probable cause to believe you should be able to answer for the charge of carrying a concealed firearm. Bond in that case is set in the amount of $1,000. Also, possession of a misdemeanor amount of cannabis. I'm going to set bond in that case in the amount of $100. Also, driving without a license. Bond in that case is going to be set in the amount of $100. Total cash bonds in your case are $1,200. However, there is a no bond hold on you for a violation of a 2016. There's a hold on you for not, is that 13? 13 for not coming to court. And let me look at that for a second here. Okay. Possession of cannabis. Not coming to court on a cannabis case. I'm going to set bond in that case in the amount of $100. All right, so, but total bonds in your case are going to be $1,300. You're going to have that posted. Does someone know you're here in jail?
No, ma'am. I want to know, can I get access to my phone?
Yes, you can. I'll sign an order to that effect so you can call somebody.
Good luck, sir.
Shannar Jennings.
Mr. Jennings?
Mr. Jennings, I find probable cause to believe you should be able to answer for 1 count of distribution or delivery of cannabis. Bond in that case is set in the amount of $100. Does he have priors, and does he come to court if he has priors? That's it? All right, Mr. Jennings, I'm going to go ahead and place you into the pretrial release program. And do you work?
No, ma'am. I get SSI.
I'm sorry, what'd you say?
Disability.
He doesn't work. He receives disability, Judge.
Oh, you relieve disability. Okay. All right, then I'm just going to place you into the pretrial release program. 1 second. I'm going to see if I want to add a special condition. Okay. Yes. I'm going to place you on a level 1 since there's no reason for you to leave your residence, and you'll be on a GPS monitor. Okay, but you won't have to post any cash bond. All right. Okay. Jacan Ramirez.
Ramirez?
All right. All right, Mr. Ramirez, I find probable cause to believe you should be able to answer for a 2013 violation of probation matter. There's a no bond hold on you for that, and you will be going to court on July 27th, which I believe is next Thursday. All right? And that'll be at 8:30 in the morning. Quentin Shivers.
Mr. Shivers?
All right. Mr. Shivers, I find probable cause to believe that you should be held to answer for an alleged felony theft. In the event you are released, you are to stay away from the Walmart located at 5001 North Federal Highway in Pompano Beach. I know he has prior petty thefts. What's the rest of his history? And more importantly, does he come to court when scheduled?
Your Honor, he also has a pending cocaine case.
Okay. All right. And when you say pending, is it, how long ago was he arrested for that? And has it been filed?
Your Honor, it has been filed.
Okay. All right. Then you have, and what is he out on for that case?
Search for that arrest. The March 11th arrest. Here, just click on his BCCI number. No, go back. Click on his BCCI number. Go down to his March 11th. There you go. Click on view arrest from March 11th. He was ROR April 14th.
He was ROR April 14th.
Okay. All right, but now, does he have a history of not coming to court?
Previous arrests. Check his don't see any prior failures to. Well, it does. I can tell you he's got a warrant out of the state of New Jersey for a probation violation from 2013.
All right. I'm going to go ahead, first of all, and revoke your ROR on your possession of cocaine case and set bond in that case in the amount of $1,000. And also on the petty theft, you're going to have to post bond in the amount of $750. So at some point, if you want to get out, you're going to have to post a total of $1,750. State, can you put on the record the possession of cocaine case number?
17-2943 CF10A.
Thank you, State.
Judge, it seems to me as though that case, Mr. Shivers was released on his own recognizance because the state failed to file charges within 30 days.
No, I asked.
But even if that's the case, he still has a release condition. You can't commit new law offenses.
Okay.
Well, I would object to that. I think if he's released without any conditions, there's no bond to revoke.
Okay. But did the state file within 30 days?
No, Your Honor. The state filed after that point, but he's...
All right, they filed, so my ruling stands. I'm revoking the ROR on that.
That would be over objection, Judge.
Okay, noted. Courtney Robinson.
Mr. Robinson?
All right, Mr. Robinson, I find probable cause to believe you should be able to answer the charge of distributing or delivering cocaine. Bond in that case is set in the amount of $2,500. Also, possession with intent to sell, manufacture, deliver cocaine. Bond in that case is set in the amount of $2,500. Total bonds in your case are $5,000.
Judge, respectfully, Mr. Robinson's asking you to consider lowering his bonds on count 1 and count 2 to $2,000 each count. At this, he lives with his stepfather. Unfortunately,
all right, I'll go ahead and do that. That's only 20% less.
Thank you, Judge.
All right. Do you work? Do you work, Mr. Robinson?
Not currently.
Okay, well then I'm going to place you on you're going to be supervised as well by pretrial services, and you're going to have a GPS monitor. That's level 1, okay? With bond.
Judge, would you sign a phone order as well?
Yes, I'll be happy to sign a phone order. Sentinel Young. Okay, now this one. Is this?
Mr. Young is here.
Okay, I don't see any indication that the drugs were tested for the presence of controlled substance. So there would be no probable cause, in my opinion, as to 1, 2, or 3. State.
We're just asking for time to perfect.
All right, 24 hours. All right, 24-hour reset for the state to perfect. Okay. Rashad Stubbs. So it'll come up again tomorrow, sir. Rashad Stubbs.
Mr. Stubbs?
All right. I can find probable cause for delivery of heroin, but I don't see any indication within the probable cause affidavit that it was within 1,000 feet of a church or a school or anything like that.
Your Honor, the statute also covers convenience store businesses.
Okay, I don't know if that was mentioned either. Let me take a look at that again. Convenience stores?
Yes, it mentions, I think, the second sentence.
Okay. Yes. Quick stop. Really? That's in this? They must have amended that statute.
No, that's been
a convenience store or a church or a school. That's
or a
weird.
park or
okay. All right. I can find probable cause then. I didn't realize that. All right. Bond in that case is set in the amount of $7,500. However, there is also misdemeanor capie is sat on you for not going to court on a petty theft, so the total bonds in your case are $8,000.
Judge, respectfully, Mr. Stubbs is asking you to consider pretrial. As far as the capias, he said he never received court notice. He lives with his parents in Deerfield. He's asking, Your Honor, if you would consider pretrial release. He's currently working. making $10 an hour for a company called Rain Gutters. He's been residing here his whole life.
All right, denied. Joseph Kobe.
I've been informed he bonded, Judge.
Okay. Jermaine Williams.
Mr. Williams?
All right, Mr. Williams, I find probable cause to believe you should be able to answer for 1 count of distribution and delivery of cocaine. Bond in that case is set in the amount of $2,500. Also 1 count of distribute or delivery of cocaine. Bond in that case is set in the amount of $2,500. Total bonds in your case are $5,000. Brandon Barr.
Brandon Barr, he's here approaching, Judge. He declined to serve public defender.
All right, you don't wish representation this morning, sir?
Yes.
You do wish or you don't?
I do.
Okay, well then I'll pass the case and give you a chance.
Yes, that's fine. Have a seat. Oh, wait, Judge.
Your Honor.
I spoke to him earlier, so I'm ready to proceed. I'll have him apply when we're done.
Okay, you need to fill out the paperwork then, sir.
Yeah,
Okay?
he's going to need to fill out the paperwork, but I have his information.
Okay. State you want to be heard before?
No, if he wants a public defender,
Okay.
obviously I have no objection.
All right, sir, I find probable cause to believe that you should be held to answer for 1 count of possession with intent to sell, manufacture, deliver cocaine. Bond in that case is set in the amount of $2,500. Also trafficking cocaine more than 25 but less than 200 grams. Bond in that case is set in the amount of $15,000. Trafficking in heroin in an amount of 4 grams but less than 14 grams. Bond in that case is set in the amount of $75,000. Possession with intent to sell, manufacture, deliver cannabis. Bond in that case is set in the amount of $1,000. Possession of drug paraphernalia. Bond in that case is set in the amount of $100. So total cash bonds in your case are $93,600. However, there is a no bond hold on you for an alleged violation of probation in a 2015 case, or is that 16? I can't tell the 5s and the 6s. Okay, 1 second. It's a 2015 case. And you will be, there's a no bond hold on you for that, but you will be going to court on August 1st at 9 a.m.
Judge, he's asking only as to count 3. The bond is set at $75,000.
You could take that up in division. He's not going anywhere. There's a no bond hold on him. You could bring that up at that hearing.
I know. That's why if he gets it resolved, he wanted to ask you, the magistrate court.
Well, he can ask his division judge. Okay, so your request is denied. Jim Mayhew.
Jim Mayhew.
All right, Mr. Mayhew, I find probable cause to believe you should be able to answer for the charge of distributing or delivery of heroin. Bond in that case is set in the amount of $2,500. Also trespass of property, not a structure or conveyance. I'm going to set bond in that case in the amount of $500. Total bonds in your case are $3,000. All right. Markendi Mater.
Mr. Mateer. Markendi.
All right, Mr. Mater, I find probable cause to believe you should be able to answer for trafficking in heroin, more than 4 grams, less than 14 grams. Bond in that case is set in the amount of $250,000. Also, delivery of cocaine within 1,000 feet of a college. Bond in that case is set in the amount of $10,000. Use or display of a firearm during a felony. Bond in that case is set in the amount of $10,000. Use of a two-way radio in order to facilitate the commission of a felony. Bond in that case is set in the amount of $5,000. But there is a no bond hold on you. Well, first of all, your total cash bonds at this time are $275,000, but there is a no bond hold on you for an alleged violation of community control or probation, and you will be going to court on that on next Thursday at 8:30 a.m. Okay, and in the event you do resolve your violation of probation and you post bond, there are additional 1 second. there are additional special bond conditions for you, sir. Any surety bond has to be fully collateralized. The net asset value of the collateral must be in an amount equal to or greater than the bond amount. Any property used to collateralize the bond shall not be further encumbered or liquidated during the pendency of the bond. The surety shall provide to the state an updated title search within 10 days of the defendant's release, reflecting recorded mortgages on the property utilized for the bond collateral. You will be monitored by pretrial services. Do you have a job, regular job?
Oh, ma'am.
Okay, then it's going to be level 1 with a GPS.
Actually, he goes to school, Judge.
Okay, then
He
it'll
goes
be
to Florida Career College studying HVAC.
okay. Then it will be a level 2 with a GPS, and that means you will be able to go to work or go to school. If you have kids, pick them up at school. Any kind of necessary absences from your residence, but you would have to provide a schedule of your absences to pretrial services, and you will be monitored by a GPS. And during the pendency of your matter, you are not to possess any firearms.
Judge, in reference to count 1, it's $250,000. At this time, he's not working. He is going to school. He lives with his mother. His mother works for a linen company, so therefore there's no way they can afford the $250,000. Would you consider lowering it from $250,000 to $50,000 just only on count 1 in the event he goes and resolves his VOP and can bond out?
No, you're going to have to take this up with the division judge. Mederick Maziel.
Mr. Maziel is approaching, Judge. He declined. He has private counsel, Mr. Ron Baum.
All right. Did Mr. Baum tell you to go ahead and get magistrated, or do you want to wait till he can come and be present?
I don't know. I only have one call to talk to him.
Did you speak with him?
Yes.
And did he tell you, did he say, I'm going to come to your bond hearing, or what?
No, it was quick. The only thing he told me is try to get bond.
Okay, well, that means he wants you to have a hearing. All right. Yeah. I find probable cause to believe you should be able to answer for 1 count of possession of alprazolam, 1 count of possession of oxycodone, 1 count of possession of cannabis, and 1 count of possession of paraphernalia. What are his priors, and does he show up in court?
Excuse me, Your Honor?
I'm trying to find out whether I want to put you in pretrial or not.
There's a 2016 cannabis.
I'm sorry. Can you ask the public defender to press the button so I can hear the court personnel or the state attorney? Thank you. Okay, proceed, Eileen.
Thank you, Your Honor. Just a 2016 cannabis.
Okay. All right, I'm going to place you. You can hear me, correct? Okay. I'm going to place you into the pretrial release program, and with no special conditions, no, you don't have to post any bonds, but if you're going to have to call in. You're going to have to just call in and make sure you follow all the other normal conditions of pretrial. Otherwise, you'll end up where you are, and it won't be as easy for you to get out next time.
Drug evaluation and follow-up treatment. Please.
Okay, I'm going to order that as well. You need a drug evaluation and treatment if necessary. All right, I'm going to order that as well. Okay. And you verified everything you need to? All right, all your information's been verified. Okay? That's
Your Honor,
it.
do I have post bond?
No, I'm not having you post monetary bonds. I'm placing you on pretrial release. Okay?
Okay, Your Honor. Okay.
Make sure you show up in court. Frederick Lewis.
Mr. Lewis? Page 25. He's coming up.
All right. Good morning, Mr. Lewis. I find probable cause to believe you should be able to answer for 2 alleged violations of probation. One from a 2014 case, the other one from a 16 case. There are 2 no bond holds on you for those matters, but you will be going to court on July 31st at 8:45 a.m. to address those. All right. Herbert Darby.
Mr. Darby's approaching.
Mr. Darby, I find probable cause to believe you should be able to answer for 1 count of possession with intent to sell and manufacture cocaine. Bond in that case is set in the amount of $2,500. However, there's a no bond hold on you for an alleged violation of probation or community control in a 2016 felony case, and you will be going to court on that on August 1st at 9 a.m. to resolve that, hopefully. Cornelius Hall. All right, Mr. All right, Mr. Hall, I find probable cause to believe you should be able to answer for the charge of trafficking in heroin more than 14 grams but less than 25 grams. Bond in that case is set in the amount of $250,000. In the event you are released, do you work?
Yes.
Where do you work?
I'm self-employed.
Okay. I'm going to put you on a level 1. If you are released, you're going to, besides posting the bond, you're going to have a GPS and be monitored by pretrial. So that's level 1. Okay?
Okay.
Carlos Rodriguez.
Judge, level 1, I don't know, will that still permit him to work?
He's self-employed. He doesn't
right,
need...
He has his own company. He's home improvement. He takes care of 3 kids.
At this time, you can move to modify the conditions of his release if he posts bond. Okay. All right. Carlos Rodriguez.
Yes, ma'am.
I'm coming. Yes. It's okay. How are you? All right. Mr. Rodriguez, sir, I find probable cause to believe you should be able to answer for the charge of possession with intent to sell, manufacture, deliver cocaine. Bond in that case is set in the amount of $2,500, and there are 2 cases for you in misdemeanor cases. One's a municipal ordinance violation. The other one is a misdemeanor. And in each, for the trespass case that you failed to go to court on, there's a $500 bond on that. And for the municipal ordinance violation of panhandling, I'll ROR you on that. But you're going to have to post bonds in the amount of $3,000, okay?
Your Honor, Mr. Rodriguez indicated to me he would like to go into the SAP program.
Okay, and he can do that while he's there.
Would you sign an order to that effect?
Yes.
Okay.
All right. I'll put you in the SAP program to address your issues. Okay? Good luck.
Thank you.
Joseph Johnson.
Mr. Johnson's approaching. Judge, you can find certain post center.
Okay. He has somebody here. She's coming up. All right. Young lady, what is your name?
Bethany Francois.
And what is your relationship to Mr. Johnson?
I'm his girlfriend.
Okay. Well,
the attorney's not here. He has a private attorney.
Okay.
So he requested no hearing.
Okay. Is the attorney going to come tomorrow, did he say?
Monday, he has a funeral tomorrow. His stepfather passed away.
Okay.
So Monday.
All right, I guess I'll receive.
The rules of procedure require.
I'm gonna make a finding, and then can I reserve as to the amount of the bond though, and that could be addressed on Monday.
I would just ask that if you could confer with Mr. Johnson if that's what he wants.
Okay, I'll inquire from him as well. All right, Mr. Johnson, your attorney won't be available to come to your magistrate hearing until Monday. I think you heard what your friend said.
Yes, ma'am.
So do you want to continue that hearing until Monday? This hearing until Monday, basically?
The only thing I would like to know, ma'am, I would like to know, could I get my bond reduced?
His attorney told him not to do anything.
Okay, your attorney said not to do anything. So, State, I'm not going to if I don't need to make a finding, I won't. But if I do, I'll make a finding and just set it for Monday regarding bond amounts.
Okay, thank you very much, ma'am.
I thank you.
I'm listening.
Thank you. I was just asking if you could just place Mr. Johnson on the record. He has a right under Florida law to have a probable cause determination within 48 hours. If he's asking for that to be extended.
All right, so there has to be a probable cause hearing within 48 hours of your arrest But you're basically saying you're willing to waive that, and it's going to be like one more day until Monday. So on the record, you're willing to waive that. Is that correct? So you can have your attorney here. Is that correct? Okay. State, is that sufficient for you?
Yes, thank you.
All right, so we're going to go ahead and reset this till July, I guess that's the 24th? Okay. All right? Reset.
Thank you, Judge.
Okay. I'm just making enough for the next judge. Brian Caldas.
Mr. Caldas, come on up, please.
Mr. Caldas, I find probable cause to believe that you should be able to answer for an alleged violation of probation in a 2016 case. There's a no bond hold on you for that, but you will be going to court on July 30th or July 31st at, looks like 9 a.m. All right? Tavares Taylor.
Mr. Taylor.
All right. Mr. Taylor, I find probable cause to believe you should be able to answer for an aggravated assault on a law enforcement officer or firefighter. There is a no bond hold on you for that. And also, that was from an arrest. That was set by Judge Sinha.
Judge, I believe he's entitled to bond on count one.
Yeah, I think so too. So I'm going to set bond in that case, I believe, in the amount of $10,000. However, there is also a no bond hold on you for an alleged, just says an out-of-county hold on a felony for a 2017 case. Out-of-county hold.
Judge, I know the out-of-county hold is from Palm Beach.
Okay.
He advised me that he's been living here. He's unemployed at this time, goes to trade school in Palm Beach. Would you consider lowering it from $10,000 to $3,500?
That's denied at this time. You could take it up with the division judge. James Hughes.
Mr. Hughes.
Mr. Hughes, I find probable cause to believe you should be able to answer for an alleged violation of probation in a 2010 case. There's a no bond hold on you for that, sir, but you will be going to court on July 31st at 8:30 a.m. Marcel Black.
Mr. Black.
All right, Mr. Black, I find probable cause to believe you should be able to answer for an alleged grand theft of property with property damage. What? 1 second. Okay, 750. That's just grand theft. I'm going to set bond in that case in the amount of $1,000. However, there are 2 no bond holds on you for an alleged violation of 2. Given the case numbers, it looks like it's not here. Out of Palm Beach on one's a 2015, another 2016 case. So there are 2 no bond holds on you for those. So Palm Beach will have to come and get you possibly. Lubin Timothy.
Mr. Timothy.
All right, Mr. Timothy, I find probable cause to believe you should be able to answer for driving with a suspended license, third or subsequent offense. Bond in that case is set in the amount of $750. However, there is a no bond hold on you, sir, for an alleged violation of probation in a 2016 case for which you will be going to court on next Wednesday at 9 a.m. Morris Edwards.
How old are you, Michelle? 54.
All right.
Where do you live? What city? House or apartment?
We can hear you.
I hear you. Okay, may I proceed? May I proceed? No, seriously. You done? I know you were asking me questions. Are you done? If not, I'll let you ask them the questions. Now I can hear you. Go ahead.
Thank you, Judge.
Okay. All right, Mr. Edwards, I find probable cause to believe you should be able to answer for 2 counts of delivery of heroin within 1,000 feet of a place of worship, a convenience business. Bond in each of those cases set in the amount of $7,500. Total bonds in your case are $15,000.
Judge, respectfully, I've been speaking to Mr. Edwards. He's 54 years old, and he advised me that he has no one to post his bond, but that he lives in Pompano Beach in an address. So if pretrial could validate his address, he has no prior failure to appear. He doesn't have a significant criminal history.
All right, let me find out. Probably not, but I'm willing to hear what are his priors.
Your Honor, he has a 2015 resisting without violence, 2003 DUI, 2002 escape, and battery on law enforcement officer.
Okay, I think he's going to have to postpone. Thank you. It is remote, but it's a serious felony.
Yes, Judge.
Elvis Valero.
Mr. Falero, come on up, please.
All right, Mr. Falero, I find probable cause to believe you should be able to answer for an alleged driving with suspended license, third or subsequent offense. Bond in your case is set in the amount of $750. Terrence Turner.
Mr. Turner, come on up, please. Judge, he declined service as public defender.
All right, you don't wish to have the public defender represent you this morning, sir?
Not at this time because I still have a active U.S. Marshal hold.
Yes, you do.
And,
all right.
The bond that
you're not going. You're not going anywhere. That's correct.
Right.
Assuming the court finds probable
I'd rather wait till the police reports and all of the facts of the case come together to see.
Okay. All right. State.
Just assuming the court finds probable cause, the state would just request to be heard before your Honor sets a bond.
Okay. All right. Sir, I do find probable cause to believe you should be held for 1 count of sexual battery with the victim of over 12 years old by using physical force but not damaging that person. What did you want to be heard on that?
Your Honor, just I'll just wait till you're done making.
Okay. All righty. I'm gonna set bond in that case in the amount of $10,000. Also, false imprisonment of an adult. I'm gonna set bond in that case in the amount of $10,000, and also tampering with a life capital felony. I guess it was the phone.
It's tampering with the 2nd-degree felony, actually.
But what was it? A phone? I was trying to. Okay, the phone. Yeah. All right. I'm going to set bond in that case in the amount of $2,000. Total cash bonds in your case, sir, are $22,000. However, you are correct. There is a hold on you by the U.S. Marshal's Office, so there is a no bond hold on you for that. State, you wanted to be heard.
Well, I would ask, Your Honor, if you should become eligible for release at some point on these charges, state would be requesting pretrial release with the GPS monitor. I'll tell you, in addition to this federal case on state charges, 2009, possession of firearm, weapon by convicted felon, 5 years state prison.
Okay, I will grant so. It would be a level 1 hold by pretrial with the condition of posting those bonds. Is that correct?
We'd ask for no victim contact with KG.
Okay, and in the event you are released, sir, you are to have no contact with KG. All right? It's a juvenile, so we don't give the name out.
Still, just with these type of offenses, we don't.
Okay, they just don't give out the actual name. All right. But first, you have to clear up your alleged violation on your federal case, probation violation. Edward Guillaume.
Ma'am, what did you say? What do you mean this person here is 42 years old?
Okay. I was informed that any time there is a victim in a sexual case, They don't like to.
42 and there's no.
Listen to me. Listen to me. No. I was incorrect. I'm saying to you, anytime there is a victim, they don't like to publicize the name. They want to protect the privacy of the alleged victims. So they're only referred to by their initials. Okay? That's why I use the initials.
My protocol or theirs?
That's the way the law is. Okay. All right. Edward Guillon.
Mr. Guillaume, come on up.
All right.
Judge's mother is here.
Waiving formal reading of the charge.
Is that you? Come on up. Come on up. Your mom's here. Sir, you're not the father?
No.
I guess not. Okay, okay, a friend of the mother's. Okay. All right, ma'am, for the record, your name?
My name is Diana Jeanette, and I'm the mother of Edward.
Okay. All right, Mr. Guillon, I do find probable cause to believe you should be able to answer for failing to comply with the registration law as a, I believe, sexual offender. And besides this, first of all, why is he subject to registration? What was the underlying case that caused this?
It's mentioned in the PC or under the first sentence.
I don't think I saw that, but let me look at it again.
It's out of Alaska.
Okay. All right. So are we supervising him, or he has to register here when it happens in another state?
Your Honor, my understanding is he is required. Any offender is required if they move
to another state.
Register. And I mean, and apparently he's aware of that because, and that's the state's concern is he did register, but he gave a false address apparently. And I can tell you with regards to DHSMV, and I checked to this date, there is still no record of any type of ID card or driver's license being issued. So it would appear that he hasn't gone to DHSMV to get some type of identification.
Okay.
So, Your Honor, I'm just going to be requesting, in addition to whatever bond the court deems appropriate, the state's going to be requesting for a pretrial release with a GPS monitor.
Judge, we can't hear the state.
Okay.
In addition to whatever bond the court deems appropriate, the state is also going to be requesting pretrial release with a GPS monitor. Simply put, I don't have much confidence about his future appearance in court, given the allegation that he gave a false address when he registered the first time, and two, it appears even up until this date, he hasn't fulfilled his requirements to register with the DHSMV.
Okay.
And it would appear, since he just moved from Alaska at the end of last year, his ties are limited.
Okay.
Well, Judge, he does have ties.
Well,
obviously.
his mom is here. His mother is here.
And,
all right.
And I think when
normally
hold on, just one
sorry.
second. I think when we get to the bottom of what actually happened here, he was living in that warehouse. He worked there, and his employer allowed him to stay there. When the police went to verify the address, the person they spoke to was not aware of the situation.
Okay.
And
right.
of course, as the court is aware,
here's what I'm ready to do. I am ready to place him into the pretrial release program with a level 2 with a GPS monitor, which means you're going to get out. I'm not going to require any monetary condition. And you're going to have to give you're working, correct?
Yes.
All right, you're going to have to give pretrial services a copy of your schedule, so you're allowed to be absent from your residence if you're going to work, going to school, going to the doctor, anything like that. But for the rest of the time, pending this matter, you are going to be basically on house arrest.
Your Honor, I would just, the only thing I would also ask is that upon his release, that he must comply with all registration laws.
All right, and upon release, you are to report in 24 hours to wherever it is you have to go in order to register as required. Okay? Is someone going to give him the address? I don't know.
yes, we'll give him a map to the pretrial.
No, I mean, he would, okay. And as far as him having to register as a sexual offender, where does he go do that? I'm not going to order him to do it and not tell him.
In the courthouse.
Okay. I guess that can be done here at the courthouse. All right? So then 24 hours of your release. After you sign up for pretrial services, go sign up and register yourself. Okay?
Thank you,
Yes,
Judge.
sir.
All right.
Your Honor, just to clarify for the pretrial officer, you did say no bond necessary, correct?
That's correct, no monetary bond. Jeremy Howard.
I've been advised to bond it.
Okay.
He's going on a GPS, Mr. Reedy, so we can't promise he's gonna be out this afternoon.
Okay. Richard Smith.
I've been advised he bonded.
Vincent Jones.
Bonded.
Good luck, Patrice.
Kirk Cade.
Who?
Kirk Cade. All right, Mr. Cade, I find probable cause to believe you should be able to ask for a delivery of PVP within 1,000 feet of a community center or a park. Bond in that case is set in the amount of $15,000. What is this temp? Why is it called temp 17
It's,
as far as
Your Honor,
case number?
Based on the time it was delivered to the court, it was given a temporary
Case number. Thank
no,
you.
temporary arrest warrant number.
Okay, that's fine. Bond in that case is set in the amount of $15,000.
Judge, would you consider reducing the bond? Right now he's looking for work. He lives with his aunt. The only person he's going to call to post the bond is his mother, who works at Publix.
What are his priors?
Yeah, the state would be objecting, Your Honor. 2016, possession of PVP, 364 days.
All right, he's going to have to post the $15,000 bond. Yeah. Selford Muir.
Mr. Muir?
All right, Mr. Muir, I find probable cause to believe you should be able to answer one count of distribution of heroin or delivery of heroin. Bond in that case is set in the amount of $2,500. However, you are being held on a no bond hold for an alleged violation of a 2016 either probation or community control, for which you will be going to court on July 27th at 8:30 in the morning. So that's a week from yesterday, next Thursday. Okay? Gerald Dennis.
Mr. Dennis, I've been advised bonded, Judge.
Keith Dennis.
Mr. Keith Dennis, come on up, please.
All right, Mr. Dennis, I find probable cause to believe you should be able to answer for possession of a weapon or ammunition by a convicted felon. Bond in that case is set in the amount of $1,000. Also, one count of delivery of cocaine within 1,000 feet of a, in this case, it was a park. Bond in that case, this case is set in the amount of $7,500. And also one count of distribution or delivery of cocaine, and that is pursuant to, I think there was a separate warrant for that. Yeah. Bond in that case is set in the amount of, by Judge Usan wanted $15,000. So total bonds in your case are $23,500.
Okay.
Brad Telson.
How you doing, on the good morning?
Okay. One second. Count two is 25,000. Okay, thank you. All right, Mr. Telson, sir, I find probable cause to believe you should be able to answer for one count of possession of cocaine. Bond in that case is set in the amount of $1,000. Also, one count of possession of cannabis. 20 grams less than, more than 3, less than 20. I'm going to set bond in that case in the amount of $100. Also, distribution or delivery of cocaine, bond in that case is set in the amount of $25,000. So your total cash bonds are $26,000, 100. However, there are 2 no bond holds on you for 2 alleged violations of probation or community control. One's in a 2016 case, the other one's in a 2017 case. And you will be going to court on that on August 1st at 8:30 in the morning. In the event, let me just see if he has those special. Yes.
The jail is asking that you dismiss count 4. It is the same as count 5, however they put the BOP on the AF warrant.
Okay. All right. So I'll go ahead and I'm just in an abundance of caution, I'll just ROR him on that.
No, they need to be dismissed.
Now, count 4. I see what you're saying. In other words, that's the same case number as the distribution. All right. So I'm going to go ahead and dismiss count 4 because it's basically a mistake. Okay. All righty. All right. So, but there's still a no bond hold on you for a violation of probation or community control on the 2016 case. All right.
Judge, in reference to count 3, Mr. Telson is asking if you would consider reducing it to $2,500.
All right,
He works for a labor pool, so
okay,
it fluctuates.
You could take that up with Judge Usan. Okay. Hollis McKenzie.
Good luck, sir.
All right.
Mr. McKenzie, come on up, please.
Okay, so this is the one where they say in the affidavit that nothing was tested for safety reasons. So how is there probable cause on any of this? What don't I know about this situation?
Well, Your Honor, I would say even without the testing, hold on. There's still,
No, it's not. Nothing was tested.
I don't think you can go on the officer's experience.
Well, first of all, actually, PC is not an issue. Whether, even if the court disagrees, Judge Usan signed the warrant. He gave probable cause to the officer to make the arrest. Any issue with that would have to be taken up either on appeal or in front of the assigned judge. But the statute and the rules of criminal procedure really are clear, unless there's something facially wrong with the affidavit.
There is.
No, that's factual, Your Honor. I mean, if the name on the warrant isn't this person, that's one thing.
All right. So okay. So it's not a matter of substance. If it's a factual matter, even if it's a matter of substance to the charges. I'll hear from the public defender on that. Is that correct?
I don't think that you are entitled to compound Judge Usan's mistake. If there's no probable cause.
I'm going to make this okay. From what Mr. Linder says, I tend to recall something to that effect. That's all I'll say. Again, I am a county judge. I don't deal with these cases. All right, but what I do want, and I'm going to give you stay 24 hours to perfect, okay? And I'm sure by now it's been tested.
Well, no, Your Honor, it might not have been because if it's sent to the lab, Your Honor, but is the court's not finding probable cause? Because the issue is, Your Honor, the reason officers have to be able to rely upon judges when they get arrest warrants signed. The Judge Usan is the one that made the determination. I don't know how we can say at this point in time that the officer didn't have probable cause to make the arrest when Judge Usan said, yes, I'm signing off on the arrest warrant,
I know,
make the
and
arrest.
if somebody swore to it, that might, granted, that might be enough to arrest him, but is that also enough for probable cause to hold him once he's been arrested?
The question is if there's probable cause to arrest him, there is probable cause to hold him. Now, certainly, Your Honor can take that into consideration when it comes to bond, but
we don't know what this substance is.
Excuse me.
Don't interrupt. Thank you.
If it wasn't, let's say, if the court could find no PC after another judge signs a warrant, then in any situation, it doesn't have to be as a matter of field testing or not. What if it's a matter of, I don't think there's enough here for in a burglary for intent to commit a crime therein. If the other judge felt it was enough, based on the other evidence, to sign a probable cause affidavit, then the officer should be able to rely upon that. Now, the defense always has the option to file a motion to dismiss the arrest warrant or suppress the arrest warrant based on that it should have never been signed. But for probable cause purposes, my belief is, and Your Honor, I'll recite to the rules of criminal procedure, Rule 3. One moment, Your Honor. And this has to do with probable cause determination, non-adversarial probable cause determination. Rule 3.133, pretrial probable cause determination and adversarial preliminary hearings. Non-adversarial probable cause determination, defendant in custody. This proceeding shall not be required when a probable cause determination has been previously made by a judge and an arrest warrant issued for the specific offense for which the defendant is charged.
All right, I don't think I can get around that.
I think you can. I don't think you have to,
I
again.
think what I'm going to do, I'm going to reset this 24 hours, get a hold of the detective in this case, and you can take it up with Judge Frank tomorrow. Okay. Reset 24. Yeah, that's on all counts. 1, 2, 3, 4, and 5. Ivan Orellana.
Mr. Orellana, come on up, please.
Okay, Mr. Orellana, I find probable cause to believe you should be able to answer for an alleged driving as a habitual traffic offender. Bond in your case is set in the amount of $750. All right?
Judge, can we have a photo order on Mr. Orellana's behalf?
That's granted. Ashton Dell, you want to see if you can get an interpreter, Spanish interpreter now? Oh, thank you. Oh, you're good. You
Ashton Dell, I've been advised bonded, Judge.
Okay, thank you. Malik Jones.
Mr. Jones.
All right, Mr. Jones, I find probable cause to believe you should be able to answer for robbery by sudden snatching without a firearm or a weapon. I am going to set bond in this case in the amount of $7,500. Also, burglary of an occupied conveyance. I'm going to set bond in this case in the amount of $5,000. And also driving with a suspended license. First offense, I'm going to set bond in this case in the amount of $500. And so total bonds in your case are $13,000.
Judge, in speaking with Mr. Jones, he did inform me that he's 21 years old. He just got a job at Target. So he hasn't even gotten his first paycheck yet. He's going to try and contact his family to post his bond. He's living in Plantation. Judge, if he doesn't have an extensive record, would you consider reducing the bond on counts 1 and 2 to $3,500 on count 1 and $2,500 on count 2?
I don't know if I'll go that low, but I would be interested in hearing his priors, if any, and his record of coming to court if he has priors.
Hold on a second. Does pretrial have any priors? He's one of these guys that they arrested yesterday.
I'll have to check your honor.
Sure, take your time.
I've shown a record of him.
Okay.
I would have to.
Do we know that he has been a resident of Florida for at least 10 years?
No, Judge.
We don't know that?
No, he hasn't.
Oh, he has.
No, he has not.
Where does he come from? Where do you come from?
From Connecticut.
Okay.
From Connecticut.
All
he
right.
relocated down here to be with his family.
Okay.
If the court will give me a moment, I do see a hit from the state of Connecticut.
Okay.
I would have to run it if the court wants to place
Please.
him on a recall.
Please. Okay, they're going to check Connecticut. Something may have appeared, so I'll pass the case.
Thank you so much.
Thank you.
So it's on recall. Have a seat.
All right. Dominic Lubin.
Mr. Lubin. Oh, no, sorry.
He's going to be a medical reset again, Judge.
And I can't proceed in his absence. He's just not coming to court. All right.
It's more complicated than that, Judge.
I know. Med reset. Med reset. 24. And Tony Dees. We reset this
Mr.
also.
Dees, I've been informed That's a medical reset.
Another med reset on Mr. D's. And Eric Wisthoff.
Mr. Woodstock is here present at main, Judge.
Okay. Okay, Mr. Wisthoff, I find probable cause to believe you should be able to answer for burglary of an unoccupied structure while unarmed. I'm going to set bond in that case in the amount of $3,500. Also resisting or obstructing an officer without violence, I'm going to set bond in that case in the amount of $500, and I'm going to find no probable causes to count 3. So total bonds in your case are $4,000.
Judge, Mr. Woodstock said he was interviewed by pretrial and he very much wants to see if Your Honor would release him to pretrial.
If the court wants to release him, that's fine.
Okay, all right, I'll state, have any objection on Mr. Wisthoff placing him in pretrial?
One moment, Your Honor. Wanted to make sure.
Yeah, check his priors. And does he have a history? Apparently, he doesn't have a history of not coming to court, or pretrial wouldn't want him.
Well, Your Honor, if the court releases him to us, he has been verified, but, you know, we don't oppose the court.
Okay. Let me find out what his history is, if any.
09 trafficking hydrocodone.
Did he come to court for that?
One moment, please. Violated probation. Let's see what else. Is there another call coming?
What was he on probation for? The hydrocodone?
Yes, he violated it. Got arrested a second time for violating. Third time for violating. Fourth time for violating.
And what year was this?
Was it?
When he was 18, I believe he caught that charge, Judge.
Let the state advise me. What?
It was a 2009 case, and all the VOP arrests were between 2011 and 2012.
Okay, it's not remote, but it's not that long ago. Yeah. All right, and do you work?
Yes, I work with my father.
Okay, all right, then I'm going to place you into pretrial release, level 2. You're going to be on a GPS monitor, which means you'll be able to go out for necessary purposes, working, school, the doctor, anything like that. And you're going to have to provide pretrial with a schedule of the times that you're going to be out of your residence, but the rest of the time you're on house arrest with a monitor. Okay?
Like you would.
No bond necessary, Your Honor?
No bond necessary.
Okay, you're being released straight to pretrial. As soon as you get out, you have to go to pretrial today, or else there's going to be a warrant issued for your arrest.
He's going on a GPS, so it's not.
Excuse me.
He's going on a GPS, Your Honor. I hear him telling him.
You may not get out today because of the GPS situation, but you'll be out as soon as possible. Okay?
Judge, can we recall Mr. Lubin?
Okay, let's recall Dominique Lubin.
The jail tells me he's probably not going to be coming to court anytime real soon. So I don't know what you want to do. Well, yes, he is. I'd rather not put it out on the record what's going on, but
we can go. What is it?
So I just asked, well, Your Honor, and I think we said yesterday we gave it one more day, and I don't have a problem with it being a reset for bond purposes. I'm just asking for a PC determination. Okay, I gotta step out for a minute or I'm gonna lose my mind. But here's what I want you to do.
Me now.
I can.
Let's go back to Mr. Jones.
Mr. Jones.
All right. Pretrial is related that back on April 24th, what occurred?
Mr. Jones was arrested. The charge said interfering and resisting. It shows that that case is still open. I have no disposition at this time.
Okay. All righty. I'm going to go ahead. I will lower the bond as far as the robbery goes to $5,000. I will lower the burglary to $3,500. So total bonds in this case will now be $9,000. In the event that you are released, do you work?
Yes, I work currently at Target, 4 a.m. to 9 a.m. And
Okay.
I have a job at a candy store.
Okay.
I have 2 more jobs, a candy store job and another job.
All right. Then I'm going to place you on level 2, supervision with a GPS, which basically means you can leave your residence for any necessary reason, work, school, picking children up. And the rest, when you're not working, basically, you're going to be home on house arrest with a GPS monitor. Okay?
Okay.
And did you give this back to me, or did I just like it? Okay. Yes. He's coming back on Monday. I found probable cause. Let me make a note for the successor judge. PC found. No bond set. Thank you. All right, and we have the interpreter finally, Mr. Martinez. Good afternoon.
Buenas tardes.
Jose Mendez.
What did I say?
Martinez.
Oh, sorry. All right, Mr. Mendez. Good afternoon.
Buenas tardes, señor Méndez.
Thank you for your patience.
Gracias por esperarnos.
Okay. I do find probable cause to believe you should be able to answer for not coming to court for driving without a license.
Veo que hay motivo fundado que usted siga detenido por no haberse presentado en frente del cargo de conducir sin licencia.
This is what happens when you don't eat breakfast.
Disculpas, no desayuné.
You were arrested this time for driving without a license.
A usted se le arrestó esta vez por estar conduciendo sin una licencia.
Okay. I'm going to set bond in that case in the amount of $500.
Voy a fijar la fianza para ese caso en $500.
And you also have 2 capiases after you for not coming to court for a DUI. Bond in that case is set in the amount of $1,000, and also another driving without a license. Bond in that case is set in the amount of $1,000.
Usted también tiene 2 órdenes de arresto por no comparecer en la corte. Tiene uno de un DUI y la fianza de ese es $1,000. Y también tiene otra orden de arresto por estar conduciendo sin licencia. Ese también es de $1,000. Ahora hay una pregunta si uno de los cargos tiene una fianza de $1,500.
Okay, it's $1,500. So, sir, the total bonds for you to get out of jail are going to be $3,000.
Sí, correcto, es $1,500. Entonces, la fianza total para que usted pueda salir de la cárcel, señor, serían $3,000.
Judge, the only request the defense would have, if you would consider on count 1 going back to the standard bond of $25 or ROR. I believe from what he told me, these are the only things in his record. He's currently working. He has no one to call because when he was arrested, he wasn't arrested with his phone, so he can't call family or boss or anything like that. Nobody knows where he is.
Well, I'll sign an order for him so he can have access to his phone.
No, he wasn't arrested with his phone. That would be the situation.
And
la defensa pide que si la señoría aceptaría en el primer cargo, reducirlo a $25 o dejarlo en libertad bajo su propia palabra, porque el señor no tiene antecedentes, es solo esto que tiene en su récord, y encima cuando lo arrestaron no tenía su teléfono, así que él no tiene método de poder comunicarse con familia o con unos amigos. La señoría iba a dar permiso para que use su teléfono, pero el señor no tiene el teléfono.
Okay, here's the thing. He didn't show up in court for driving without a license. And he was also charged at that time with the DUI, which he didn't show up, therefore didn't show up in court for either. So this would be a second alleged driving without a license. The bond will be $500.
Ya que el señor,
$3,000.
El señor no compareció, no se presentó cuando estaba acusado de conducir sin licencia. Después lo arrestan nuevamente por un DUI y tampoco se presenta. Entonces, este sería un segundo cargo de conducir sin licencia. Así que no, queda a la misma cantidad, $3,000 de fianza.
Okay. Thank you. That's
Gracias.
Judge, we're done here at Maine. Do you know what time we're going to be starting this afternoon?
What time? We don't have to start again at 1. Why don't we do it 1:30 since it was a long morning? How's that sound? Or does everybody want to start at 1?
I'm good to go at 1, but whatever everyone else wants is fine with me.
1:30 is good.
I know the deputies are requesting 1:30, but
Okay,
whatever.
let's do 1:30. Okay.
1:30, we'll be back.
Because I don't even, are those are the ones for 1:30? That pile? Yes. Okay, all right, yeah, 1:30.
Interpreter may be dismissed, Your Honor?
Yes, thank you.
You're welcome. My pleasure. Thank you.
The DTU's up here. I know. I was joking around about that. I'll call Kim. I don't care, but no, that's a joke.
Okay, court's in recess till 1:30. All right, good afternoon. State, I have a couple I'm going to call out of turn for Mr. McLawrence, and I'll take the ones that you wanted me to call, right?
Thank you, Judge.
Okay. All right, so the first one I'm going to call is Katie Peterson.
North Broward.
Okay.
She's approaching, Your Honor.
Thank you. All right. All right, good afternoon. Ms. Peterson, I find probable cause to believe you should be held to hands for the charge of being in violation of a city ordinance for loitering for the purposes of soliciting prostitution. If you want to resolve this case today by pleading no contest, I will take note of your time in jail in lieu of court costs. And order you to stay away from the location of 2700 Northwest State Street in Fort Lauderdale. And if you don't want to accept that, you're going to have to post bond in the amount of $500 if you want to be at liberty while this is pending, or you can remain in jail. What would you like to do?
I'd like to,
Close it out?
yeah, solve it.
Okay, so ordered.
Judge, just so the record is clear, this is, I know it looks like a city ordinance, but it's actually a county ordinance.
Yeah, I think they wrote that. Okay, and thank you. You'll be released.
Thank you, ma'am.
Jorel Hyacinth.
And Judge, just for the record, are you pointing my firm on Ms.
Oh, yeah,
Peterson?
for the record,
Okay, thank
I'm
you, Judge.
pointing the law firm of Jara McLawrence.
Jorel Hyacinth is also in the, he's in North Broward as well,
Okay,
Judge.
thank you.
I think the second one.
Is Mr. Hyacinth coming, or
Yes, you just get
a
a
couple of
brief
minutes?
sec. Yes.
Sure, I'll recall. Let me know
Thank
when
you,
he's
Judge.
there. Okay. State, which ones did you want to have called out of?
Shadiq Perch and Kevin Paz, Your Honor.
Yes. The case of picking the wrong victims, huh?
I'm sorry?
The case of picking the wrong victims.
Yeah, that's an understatement.
Just for that. That was towards the end. What did I do with those? Oh, here we go.
But you know what? It's every man's downfall. You know, the reason I went back out there. Good girl. See what you guys do to us.
All right.
You make it stupid.
Let's do Shadiq Perch.
Judge, he's approaching. He's here at Maine. He declined to service the public defender.
All right, you don't wish to have representation this afternoon, sir?
No, ma'am.
Okay. All right, sir, I find probable cause to believe you should be held to answer for a robbery with a firearm.
And Your Honor,
State?
In full candor, it's actually an attempted robbery. So
It was an attempted robbery. They didn't actually take anything. They only got to the point where they told them to give them their valuables. Okay.
Which is just significant because it won't be a PBL. He's bond eligible.
Right. Okay.
Your Honor.
Anyone want to testify? All right. You want to put your appearances on the record? What's your name, first of all?
Detective John Kidd.
Okay. And you are?
Detective Danny Dunn.
And you each, do you each swear or affirm testimony you're about to give is the whole truth, nothing but the truth to help you?
Yes, I do.
All right, State, you may proceed.
And frankly, either detective, just before you speak, if you just announce who's speaking so the court reporter will know. If either of you have any concerns for the safety of the community or Mr. Perch's future appearance in court, if you could just advise the court based on your investigation in this matter.
Okay, it's this Detective Kidd speaking. Based on the initial investigation that I took over assisting Detective Smyers, who had the initial case, I had the opportunity to interview the victim, and he basically made it very clear that these guys were basically preying on him, and he did notice them at the bar watching him and the girl he is with, and basically followed them out. So they're basically preying on people. We don't know at this point if there's other robberies involved or not. Okay. That's what the ongoing investigation is about.
And Detective Kidd, I don't know if you have any information. I see on Mr. Perch's booking sheet, it says that he was born in Jamaica. Do you have any information?
Yes, I believe he's a Jamaican national. He's currently undergoing some immigration status issues here. So it'd be pretty wise to try to revoke him from leaving the country until this is resolved.
Your Honor, I can tell you, and I'm looking at his FBI, he was picked up in 2014 by ICE as a deportable alien. I don't know what happened. I'm just advising the court. As far
but there's no current immigration hold on him.
There's nothing in the system that
any
you
hold. Can tell.
Your Honor, I can also advise the court as far as criminal history. In 2013, out of Dade County, Mr. Perch was convicted of aggravated battery of great bodily harm. Your Honor, based on his prior conviction for violence, his status as a Jamaican national, Your Honor, I'm going to be requesting a $50,000 bond. I'm also going to, obviously, would be asking for no victim contact. I'd be asking for pretrial release with a GPS monitor should he post his bond. And I'm also going to be requesting that the court order that Mr. Perch surrender his passport to the clerk's office before he is eligible for release.
All right. Anything else of this witness?
No, no, Your Honor, nothing further from the state.
Or the other witness either? All righty. All right, so I am going to follow the request of the state, sir. I'm going to set bond in the amount of $50,000 in your case. And the conditions that he mentioned regarding your release, if you do post bond, I'm going to agree with. And also, you are going to have your passport surrendered before you would be released. And you are to have no contact with Jonathan Perigny.
And Judge, as far as the level,
it would be level 1.
Okay, I just wanted to clarify.
Oh, it's level 1. Okay, that's a GPS monitor if you are released. All right. Kevin Paz.
Mr. Paz is approaching. Come on up, Mr. Paz.
He's the co-defendant. Yeah. Okay. All right, Mr. Paz. I do find probable cause to believe you should be held hands for robbery, attempted robbery with a firearm. Does the state wish to be heard?
Your Honor, one moment. And Your Honor, I'm being advised, and I apologize if this is mentioned in the PC, but I'm being advised, and I think it's an aggravating factor that Mr. Paz, according to the victim, Mr. Paz was the one that actually possessed the firearm.
Okay.
While the attempted robbery was committed. I can tell you, Judge, there were, as a juvenile, there were previous arrests for similar offenses out of Dade County. They were dropped. Your Honor, I'd be asking for the same bond conditions. Also noting, Your Honor, I would note out of concern that I'm showing Mr. Paz resides in Miami Gardens. So there is a certain level of concern for Mr. Paz coming up from Dade County to commit this alleged offense in Broward. I'd be asking for the same bond, no victim contact, and the same pretrial with the GPS supervision conditions.
All right.
Judges, if the request could be heard.
Please.
Judge, in speaking with Mr. Paz, he's been residing here his whole life. He's 20 years old. He is a U.S. citizen. Unfortunately, he just lost his job. He was a server making approximately $5 an hour plus tips. He's been residing here, like I said, all his life. He's a graduate of Carroll City High School, class of 2014. He lives with his parents in Miami Gardens, which is basically almost a minute away from the line of Broward County. Judge, his parents are in the hospitality business. They're also servers in the same hotel that he was previously working in. Judge, considering his strong ties to community, his lack of any sort of significant priors, Judge, we'd be asking you to consider setting a $20,000 bond on Mr. Paz's behalf.
Okay. I'm going to go ahead and deny that request. I'm going to set bond in the amount of $50,000. I'm also going to agree to all the requests that Mr. Lender has put on, as far as if he is released on monetary bond.
Your Honor, Mr. Hyacinth is it?
I'm sorry, and also a stay away. And I don't think I mentioned it for the last gentleman, but it applies to him as well. Stay away from Samantha Maloney and Jonathan Perigny if he is released. The alleged victims.
North Broward, Your Honor. I have Joel Hyacinth.
Okay.
Hyacinth.
All right, what did I do? Did I give you Hyacinth back? Yeah, 1 second. Oh, no, he's the second look. All right. All right. All right, Mr. Hyacinth, apparently you've been in custody for 41 days for alleged violation of a Broward County ordinance. If you want to resolve this case today by pleading no contest, I will take note of your time in custody in lieu of court costs. I'll withhold adjudication, and I know you've been represented by Mr. McLawrence. Do you want to accept the court's offer to resolve your case today, or I'll release you on your own recognizance and you can still go to court to resolve the case? What would you like to do?
Resolve it.
Okay, so ordered. You'll be released.
Thank you.
Okay.
Thank you, Judge.
All right, state any others I need to call out of turn?
I'm not asking for any, Judge.
Okay. All righty. Victoria Macropolo.
Those robbery cases.
Sign this. I see. Did she bond? Victoria Macropolo? Nobody's home? Should be main jail.
No, it's North Broward, Judge.
Okay.
Sorry, I didn't say anything.
Okay. Well, North Broward, nobody's home. I'll pass it. Leslie Mack.
Bonded, Judge?
Thank you. Jonathan Medina.
Mr. Medina is approaching, Judge. He's inquiring if Your Honor would consider resolving his case
Yes,
today.
I would. All right. Well, first of all, Mr. Medina, I do find probable cause to believe you should be held to hands for the charge of petty theft, less than between $100 and $300. Also, resisting an officer without violence and violation of a municipal ordinance, drinking on public property. If you want to resolve these cases today by pleading no contest, I will take note of your time in jail in lieu of court costs, and you will withhold adjudication. Would you like to accept that, or do you want to post some bond and go through the court procedures?
No, I'm accept that.
You want to go out? Okay, so ordered. All right, you'll be released. George Pinion.
Mr. Pinion is approaching, Judge. He declined the service of public defense.
All righty. Mr. Pinion, you don't wish to have representation this afternoon?
That's correct.
Okay. All right, sir, I do find probable cause to believe you should be held to hands for the charge of DUI, driving under the influence of alcohol or drugs, allegedly a second offense. Bond in that case is set in the amount of $1,000. Also, DUI with property damage to one other vehicle. Bond in that case is set in the amount of $100. Also, leaving the scene of an accident involving property damage. I'm setting bond in that case in the amount of $500. And refusal to submit to a chemical or other test of your breath or blood, I'm going to set bond in that case in the amount of $500. Total bonds in your case are $3,000. Other than his DUI issue, does this gentleman have any other criminal history or failing not to show to court?
That's it? He is prior. Yeah. Well, I mean, maybe nothing else. No, I'm not showing any, Judge.
Okay.
Just the prior DUI, that is.
Yes, I saw that. Okay, Mr. Pinion, if you want, I can play. Is somebody going to be bonding you out, as far as you know?
Yes, we're in process of that.
All right, because otherwise I could put you into the pretrial release program, which of course has certain conditions. If you go into the program, you have to call in, you have to sign up, you have to call in every few days and whatever. And obviously, you would probably be subject to screenings of your urine for the presence of alcohol or intoxicants. Do you want to? I can write that bonding, or I could put you in the pretrial release program. What would you like to do?
I would like to.
Without, you wouldn't have to post any bonds then.
No, I would like to post bond.
You want? All right. I'm just going to write bonding. Okay.
Yeah.
All righty.
Yeah.
So that to whoever if you can get a hold of someone, tell them your bonds are. It's $3,000. Okay.
Okay. Can I have a question?
Sure.
If I can't reach a person, I have credit cards in my property. I might be able to bond myself out.
Okay, I will sign an order to allow you access.
If you tell one of the deputies that you can self-bond, Mr. Pinion, if you tell the deputies that you can self-bond, they'll assist you with that.
Okay, I thought I had to sign an order.
Okay, good luck.
All righty. Ellie Adams.
Mr. Adams is here approaching. Come on up, Mr. Adams. She wishes to
Yes, I know.
resolving this case.
All right, Mr. Adams, if you want to resolve your case today by pleading no contest, I'll take note of your time in jail in lieu of court costs. And I'll withhold adjudication. And if you want to proceed through the court system, I'll just release you on your own recognizance. And both ways, I am ordering you to stay away from the Walmart located at 2500 West Broward Boulevard in Fort Lauderdale. So do you want to close out the case today with a plea of no contest, or do you want to just be released and go to court and fight the charge?
I want to close out the case.
All righty. All right, so a plea of no contest, so ordered.
No contest.
Okay, so ordered. Anderson Garrido Monserrate.
I'm in advisory bonded.
Okay. Thank you. Javon Smith.
I'm in advisory bonded.
She revoked on the theft.
Anthony Irizarry.
He's here present, Judge Amin.
All right, Mr. Irizarry, I find probable cause to believe you should be able to answer for the charge of leaving the scene of an accident involving property damage. I'm going to set bond in that case in the amount of $500. Also, DUI. First DUI, allegedly, driving under the influence of alcohol or drugs to the extent your normal faculties were impaired. Bond in that case is set in the amount of $500, and also possession of cocaine. Bond in that case is set in the amount of $1,000. Is somebody posting bond for you?
I can't reach anybody. All my phone numbers are on my phone.
Okay, I can sign an order giving you access to your phone, but you're saying your phone's dead? Are you saying your phone is dead?
No, I'm saying my phone was not found. I got.
Oh, okay. So you don't have a phone all right. Okay. What are his priors, and if there are any, does he have a history of not coming to court?
I don't know. Why do I have two George Pinions? I don't know who this is.
Who's this, Your Honor? This is Anthony Irizarry.
Is that it? Yeah, look. They gave me this guy. They gave me George Pinion's paperwork again instead of Irizarry.
A petty theft 2003, Your Honor.
All right. Okay, Mr. I'm sorry, I interrupted you.
Sorry, possession of cocaine 93.
Okay, that's fine. They're remote. All right, Mr. Irizarry, I'll be happy to place you into the pretrial release program if you're interested. Okay?
Yes,
make sure you adhere to the conditions of the program. I won't require you to post any cash bonds to go with that. And just make sure, again, that you adhere to the conditions. Otherwise, you will end up where you are and you won't be getting out as easily. All right?
Thank you, Judge. Based on the charge, we're going to ask that the defendant submit to an alcohol evaluation.
Sir.
Follow-up treatment.
Okay. Also, I'm going to order an alcohol evaluation to see if you have an issue. And if they determine you do, you'll have to take whatever treatment is recommended. Agreed? All right.
Thank you. Yes, standard pretrial, no bond necessary.
Yes, into pretrial. Stephen Hill?
Mr. Hill, come on up, please.
All right, Mr. Hill, good afternoon. I find probable cause to believe you should be able to answer for a burglary of an unoccupied structure while unarmed. I am setting bond in your case in the amount of $5,000.
Sorry.
Okay.
Judge, he's requesting if Your Honor will consider pretrial.
Based on the facts of this, I'm not really inclined to, but I would like to hear. I will hear what his priors are, if any, and if he has priors, what his history of coming to court is.
Okay. I was just going to go by his DOC. Yeah, Your Honor. Out of Citrus County, 2008, 4 separate burglaries of structures.
All right, thank you. That's the post bond, $5,000. Jermaine Hall.
Mr. Hall, come on up.
All right, Mr. Hall. I find probable cause to believe you should be able to answer for robbery with a firearm. I'm setting bond in that case in the amount of $10,000. Also, 1 count of carjacking with a firearm. Bond in that case is set in the amount of $10,000. An aggravated battery with a deadly weapon, I'm sending bond in that case in the amount of $10,000. Total cash bonds in your case are $30,000. However, there is also a no bond hold on you for alleged not coming to court on
5,000. 10.
Let me get that. Or there's a hold on.
Looks like
for
a
not coming to court
2007 case, Judge.
on a possession of cocaine with intent to deliver or sell.
Well, wait.
There's a no bond hold on him for that.
Your Honor, I'm sorry. Are we still on Jermaine Hall?
Yeah.
1 and 2 are punishable by life offenses.
Okay, so then I have to make a finding of proof evident or presumption great.
That's what we.
I'll need a copy of the probable cause.
Okay, all right.
Judge, the defense wouldn't object for $20,000 bond on count 1 and 2.
All right, well, if it's PBL. Okay, let me go ahead and pass that in order to have the public defender in the courtroom review the PC affidavit, and then I'll make a ruling as to proof evident or presumption great for purposes of this hearing. All right. O'Neill Tennant.
Bonded.
James Tucker.
Bonded.
Keep it. You know what? Do me a favor.
Ezekiel Smith.
M.A.
Mr. Smith. Sir, I find probable cause to believe you should be able to answer for an alleged 2016 violation of probation. There's a no bond hold on you for that, but you will be going to court on July 31st at 8:45 in the morning for that. All right?
Good luck.
Jordan Anelian.
Mr. Anelian.
All right, Mr. Anelian, I find probable cause to believe you should be held to answer for grand theft of a firearm. Bond in that case is set in the amount of $1,000. Also carrying a concealed firearm. Bond in that case is set in the amount of $1,000. And resisting or obstructing an officer with violence, I'll set bond in that case in the amount of $1,500. Total bonds in your case are $3,500. Stephen K. or Ray.
Mr. Stephen Ray is here. Judge, he just showed me disposition papers he was brought to court this morning on his VOP in front of Judge Barbara McCarthy.
Can you just tell me the case number?
Yes, 11-19628 CF10A.
Okay, and what's the disposition?
It says reinstated and modified extended 5 years probation. All previous special conditions apply. Dated today, signed by the Honorable.
That's fine. So I don't ROR him. What do I do?
Just asking the court to find PC. The paperwork's going to go to the jail, and they will process it based on what Judge McCarthy did today.
Okay, so basically it'll be processed and he'll be released pursuant to the conditions in the disposition.
Okay, I'm just hoping he's released today. I don't want him held any longer than necessary.
Well, I'm not doing
supposed to be
anything.
released.
Yeah, I'm not doing anything to hold him. Okay. All right.
Should be. According to Mr. Lunder, you're going to be released today.
Well, I don't know. I don't work for the jail or BSO. I don't know when he's released.
Hopefully, unless he's not has a GPS or anything, right?
No.
Usually they're out. Aren't they out by midnight? Isn't that how it usually works?
I've been hearing sometimes stories they're out like super late. I mean, it's odd, and it's probably the
volume,
the exception. But we now know he should be released.
Okay, well, he knows he's going to be released sooner rather than later. Okay. Chesley Sanmelis.
All right.
Your Honor.
Yes.
This case is
like a change of charge from what to what?
It was it was originally a robbery with a weapon, and for whatever reason, he was being held no bond. This is like the case we had yesterday, where we merged the robbery with the weapon with the mask enhancement.
Okay.
He's got multiple other holds for the same charge at $75,000 each.
Right.
I was just going to be asking that the bonds be kept the same, $75,000 each as those bonds.
All right. So they're changing your charge to robbery with a weapon and a mask, and basically it's a change of charge. So we're going to keep the bonds at where they were on each count. It's $75,000 on each count. All right, I'm not increasing it.
Yeah, and Your Honor, I guess there was GPS well, there wouldn't have been
whatever conditions were from yesterday apply today. Okay. All right. Anything further? Okay.
Judge, they have Miss Macropolo.
Okay, thank you. She is at
North Broward.
Thank you.
75.
All right. All right, Miss Macropolo, I find probable cause to believe you should be able to answer for 1, 2, 3, 4, 5 not coming to court on 5 misdemeanors. I think some of these might actually be my cases.
That's Irizarry. Macropolo from earlier on the docket.
All right. As far as the first one goes, that is a misdemeanor for possession of a misdemeanor amount of cannabis. I'm going to set bond in that case. I'll lower it to $100. Is there someone who's going to be able to post bond for you?
I was trying to have my baby daddy post bond for me, although I never got my phone call up in the jail.
Okay, I could give you access to your phone. Do you need that?
Please.
All right, I'll sign an order to that effect. You also failed to come to court for possession of drug paraphernalia. I'm going to ROR you on that. You also have another, you failed to come to court on another misdemeanor for failure to register a motor vehicle. I'm going to ROR you on that. For the tag not assigned to vehicle, I'll ROR you on that because is my prosecutor here? No. Usually they no pros that. And here's the thing, as far as the driving with the suspended license with knowledge, I guess that was charge 3. On that one, I'm going to have you post bond in the amount of $100. So the total bonds that will have to be posted is $200, and the other 3 charges I'm RORing you. I'm releasing you on your own recognizance. Ms. Macropolo, please come to court. I probably would have made you an offer to resolve all your cases today, but for this one, if you come to court, you're going to most likely be eligible for a program where you'll be given time to get your license reinstated. But if you don't come to court, you can't be placed into this program. Okay?
I've already gotten my license reinstated. I've gotten
Perfect, then come to court.
I
And
already got a new insurance.
good, then it's gonna get dropped on the spot when you come to court, so please come to court. I think you're one of my cases. This all happened in Hollywood, right?
I believe so, yes.
Okay, please come to court.
I believe it was Hallandale.
All right, but the same thing will happen, but you need to come to court to resolve these two cases, and you're gonna have to post $200, okay?
All right. Do I post 10% of the $200 or $200 total that I have to post?
200, total of 200, okay?
All right, thank you.
Okay. Okay. Thank you. Sorry. All right.
Your Honor, on that other one, can you also write Ellen as a miscellaneous instead of the CF? No, for the revoked bond part.
Oh, you want me to initial it?
And write MM instead of CF.
Where? Just anywhere?
On the case number that's revoking.
Oh, it should be MM.
Yeah. Thank you.
Okay. Alan Martin?
I've been informed he's in regular court, Judge.
Okay. So reset, or is he there on this charge?
I could check.
Possibly. It's from about 6 weeks ago.
Yeah, it might be a random. I'll check right now.
All right. I'm just going to write in court reset.
No, he's actually having an Arthur hearing.
Okay.
So
on this?
Definitely. Your Honor, what I would ask is that, I mean, he's essentially having a bond hearing right now. My concern is if we reset it in here, that something might happen that will change what Judge Cohen does today.
So what should I write then? Just in
I would
court?
ask that, actually, if we could reset this, I'd say it should be reset for Monday before Judge Cohen, since he does his first appearances also.
Okay, reset Monday. So that's 7/24. Okay.
You can recall Mr. Hall if you want to, Judge.
All right.
Jermaine Hall, come on up. Jermaine Hall.
Okay, you've had a chance to review is there anything you'd like to add?
No, Your Honor. Yes, I have had a chance to review, and no, there's nothing I'd like to add.
All right, state you want me to declare proof evident, presumption great, in order no bond hold on him?
That's what we'd be seeking on 1 and 2, Your Honor.
All right, on counts 1 and 2. All right, so as to counts 1 and 2, there is a no bond hold on you, sir. And as to count 3, I'll leave that at $10,000. And there's also a no bond hold on you for an alleged violation. Well, that's not a violation. It's not coming to court in a 2007 case.
In light of the no bond hold on that 2007 case, we will be deferring any argument related to proof evident presumption great.
Okay, noted.
Yeah, we just, in abundance of caution, we just request an order of no vacant contact.
Okay, sir, in the event you are released at some point, you were to have no contact with the alleged victim in this case. 1 second, I think I saw it here somewhere.
I can get that for you, Judge. Let me see, what's the case number? 1733.
Baker.
It is, Azelle Baker, Judge.
Azelle Baker. In the event you are released, sir, you're not to have any contact with Azelle Baker. Chris Epstein?
Good morning, Your Honor.
Okay, thank you.
Hope not.
Afternoon.
All right. You're back here because they're doing a change of charge on you.
Judge, it seems to me it's the same one.
I have charge number 2. Somebody want to elucidate this for me?
Your Honor, it was originally, it came through originally as a credit card fraud. It was filed as criminal use of personal identification information.
That's what this one is.
That's what it was changed to.
Okay. All right. So you're being charged now with criminal use of personal ID or information of another. I'm going to leave the bond the same, which is $1,000. Okay.
So it's the same. It's the same charge, Your Honor.
No, it's a different. It's a different charge, same bond. Okay.
I think yesterday you were here on count 1,
right,
and today you're here on count 2.
Right.
Mr. Epstein is wondering whether the court would consider pretrial release.
There was a reason why we didn't do it yesterday.
He was arraigned yesterday morning by Judge Siegel. So.
Okay. On what? On what case? This case?
Yes.
Right.
So why? On both counts?
On everything.
So what was what happened at that here? Why wasn't this brought up?
He was arraigned. He's got a status conference. He's got a calendar call for September 15th.
Okay.
All right, Chris, you have a public defender. Then I'll let your PD file a motion in front of Judge
Siegel.
Judge Siegel to get your bond reduced.
No, it's an additional charge, but you may have already been arraigned on it. But just the way the things work, it's coming up in front of me. I'm not doing anything to put you in a worse position.
No, I understand that, Your Honor. I just didn't know. I didn't understand myself.
Okay.
No, you're not the only one.
Okay. All right. Good luck. Douglas Tuback.
Mr. Tuback's at the power rod facility, Your Honor.
Okay. All right, Mr. Tuback, you're here also on a change of charge. Okay, he is charged now with, you were charged with burglary of a structure unarmed, with an assault, just burglary of an unoccupied structure unarmed.
It's, Your Honor, basically it's still a third-degree felony. It was from occupied to unoccupied. Bond was originally set at, looks like $5,000.
I usually do around $5,000. If it's unoccupied, I'll lower it to $3,500. Okay? I'm lowering your bond $1,500 if someone can post it for you, sir.
He has some no bond holds anyway, Judge.
All right, and of course that's subject to any other holds that you might have on you. Okay?
Thank you.
Sorry. Okay. All right, we have taken care of all the new arrestees, so.
It's 3,500, so she'll reduce it 1,500.
I only have one case, I believe this is the one from yesterday, to Darius Preston.
1 moment, Judge.
Your President, your name?
The state is checking to see if they filed an information on you.
Actually, this wasn't the one from yesterday,
No?
Your Honor. This is, but we have not filed an information.
All right.
Mr. Preston, he's entitled to release.
All right, Mr. Preston, I'm going to sign an order releasing you on your own recognizance. That doesn't mean this is over. It just means that the state hasn't done what they needed to do in a timely fashion, so you're entitled to be released. But I would tell you, if you get anything in the mail telling you you need to go to court, you need to go to court. Otherwise, you could end up back here for not going to court.
Mr. Preston has an out-of-county hold anyway, Judge.
Oh, he has other holds?
Palm Beach.
Okay, thank
Palm
you.
Beach is
Oh,
gonna
yes.
come pick him up.
Palm Beach is going to be picking you up, and now there's nothing stopping them from taking you back to Palm Beach. All right? Good luck.
Okay. Judge, we're done here at Maine.
Okay, I have Marquetta Lawson.
Have a nice weekend, Hector.
She's not appearing on any docket, but I have a... Okay, that's fine. Marquetta Lawson, I just signed. It's a.
Yes, she's entitled to. Well,
Is she at Paul Ryan? Where is she?
Yeah, Your Honor, can we ask if we could pull up, because normally what I ask, I obviously have no objection to the ROR.
Right.
But in an abundance of caution, I ask that the court remind them, especially since this is a domestic violence case, that there is still a no contact order.
Okay, not a problem, but I don't know where she is.
She's at Paul. She should be at Paul Ryan.
All right, no one is there at the moment.
No, there's a deputy. Yeah,
oh, deputy, we need Marquetta Lawson.
I have her brought up right away, Your Honor.
Thank you. All right, while she's being brought up, let's talk about Mauro Carrillo.
Good afternoon, Your Honor.
All right, Mr. Carrillo has been in for 5 days. I'm just curious, is the only thing holding him?
That's what I'm checking.
Okay.
I'm showing you posted a bond.
Okay, bond has been posted for you, so you will be released. But I'll still make you an offer. Do you want to just resolve this case today by pleading no contest? I would take note of your time in jail in lieu of court costs. So your bond doesn't have to be posted. All right?
Yes, ma'am.
All right. So ordered. And that's a withhold of adjudication. And Frederick Effler?
Yes, ma'am.
Okay. All right, Mr. Effler has been in for 5 days for two counts of battery and 1 count of indecent exposure.
Yes, Judge, based on, you can be provided with a copy of the PC, but
yeah, I was going to say, I think I'd like to read about this one. Would the state be seeking additional time on this case?
Your Honor, I'm asking that, I haven't spoken to any victims, and I sort of remember the allegations. I really would be asking that the bonds be, I think the bonds are appropriate. You said $1,000 bond on each count.
Okay.
And that it should go to division.
All righty. Let me go ahead and review this again. Ah, yes. Yeah, I heard this earlier in the week, didn't I?
Yes, you did.
Okay. All right. The bonds that I set are still it's $1,000 on count 1 and $1,000 on count 2 and $1,000 on count 3. So your bonds are going to be $3,000 in this case. Will be set in division. All right. That's my ruling. Okay. So now we're just waiting for Miss Lawson.
Did we have a David Godnick?
What?
Did we handle that? I have a David Godnick up for a second.
Wasn't
He's
that
a
yesterday?
medical reset.
Oh, okay.
He was a medical reset at Maine. So
Okay.
now
Thank
we're
you.
officially done at Maine.
Okay. Thank
See you,
you.
Miss
It's been a
Lawson.
pleasure. Miss Lawson.
Yes,
All right. We're here to find out if the state has filed an information on you. State.
State has not yet filed an information. Ms. Lawson's entitled to ROR on these charges.
All right, Miss Lawson, I'm going to release you on your own recognizance on these 3 charges. That doesn't mean it's necessarily over. I'm just suggesting that, first of all, the no contact order that I placed on you in this case is still in effect until further order of court. And if you get any notices in the mail telling you you need to go to court, you need to go to court, or there'll be a warrant out for you. But keep in mind that no contact order is still in effect, even though I'm releasing you. Okay?
Thank you.
All
Thank
right.
you.
Okay. Okay, anything further this afternoon?
Judge, it's been a pleasure. I think there's one more order I'd ask you to sign.
I'm here.
I'll be back.
Okay. Yes, it has. I really would. Okay, let's go up. No, wait.